59.
Hmm.
Order cited, my lord. I have instruction from my client not to press this application, my lord.
59.
Yes, my lord.
Mr.
A. Tiwari.
Huh?
A. Tiwari, lord.
A. Tiwari, learned counsel for the petitioner, submits that he has an instruction not to press this writ petition. List of accordingly. Writ petition stands dismissed as not pressed, closed as not pressed.
With a liberty to file afresh if required, my lord. Because against the inaction of the police authorities, my lord, the application is filed. Presently, my lord, the investigation is going on, my lord. That is why, my lord, I'm just.
You are always a
Oh,
liberty.
yes, my lord. Oblige, your lordship. Oblige,
You
your
have the
lordship.
liberty.
Oblige, your lordship.
Please, Your Lordship. I beg to mention item number 51, Lordship.
51.
Yes, Lordship.
Yes.
With consent of petitioner side, Lordship.
Hmm.
So, for adjournment, Lordship. Let the matter come after 2 weeks, Lordship.
You are for
For respondent number 4, Lordship. Private respondent.
consent.
Yes,
Again, consent.
I am appearing for the petitioner here. You have agreed, subject to court convenience, it may be fixed on 24th. I have already 24th of.
The on the consent of Mr.
I'm BK Jain for the.
BK Jain, learned counsel for the petitioner, Mr.
Ajay Ghosh. For
Ajay Ghosh,
yes,
learned counsel for respondent,
respondent number 4, Lordship.
respondent number 4. Press for adjournment of the matter to 2 weeks. List of praise allowed. List after 2 weeks.
No, Lordship, 24th. We have agreed for 20.
You may have agreed
Lordship,
after
just-
2 weeks.
I pay, no, because
2024 matter.
that's why there is some interim relief here.
Huh?
It may be on 24th.
After 2 weeks. List after 2 weeks. We fixed so many matters on 24th.
May I please, your lordship? I beg to mention item 63.
Hmm.
Lordship, my senior is out of station. We have taken the consent from the other side.
You are for?
Petitioner.
Why this is listed for orders, we'll see. What order has to be passed? Will you be there?
Yes.
Item number 10 to 39. Need some, I have to take some instruction.
What instruction?
The officer has changed.
What is the issue?
Was actually
Transportation of coal, lord.
transportation of coal, Lordship.
Hmm.
Coal, actually, the AMDC, the Mineral Development Corporation has the authority or not. So we have.
Have you filed the affidavit?
No,
Not yet,
Lordship. Actually, some copies it was not served. They have served recently, Lordship. That's only 39, and there's 29 petitioners.
Hmm.
Some are from Delhi also.
So why you must be knowing whether you have the authority or not.
We have the power.
Hmm? You argue the matter.
Lordship,
discuss the
not
matter.
today, Lordship. Only today I need a some time, Lordship.
Why?
Because Lordship, affidavit.
If you have the power, your authority will allow, will dismiss the writ petition. If you don't
Lordship,
have,
then also, Lordship, give me some day. The officer has changed, Lordship. I have instruction to take.
what's the question of officer?
No, Lordship, actually, the officer is also not, I am also not ready, Lordship, today.
You are saying that you have the authority. Why? The permission is to be issued. They have sought for a permission, NOC,
Yes.
for transportation.
Also, we have issued a letter, Lordship,
Hmm.
that for transportation through railway.
Hmm.
So they should have taken NOC from us.
Hmm.
So Lordship has stayed the operation and amended it. We have to check the documents and check the documents at the railway. That way, this has been amended. The interim was been modified, Lordship,
Saying what?
saying that we have the right to check it, but not to take NOC from as of now. They should not take NOC. That is being modified to that effect, Lordship.
We'll see.
Lordship, kindly give me some time, Lordship, at least 7 days time, Lordship. May fix a date, Lordship. I'm not ready, Lordship, today. Please, Lordship, today.
You are Mr.
P. Sharma.
For what?
AMDC, for respondents.
AMDC,
AMDC, Mineral Development Corporation.
Assam Mineral Development Corporation. You have issued the, you have issued the letter
Yes, Lord. My letter is being.
for NOC,
Yes, sir.
directing them to obtain NOC from you.
Yes.
On the prayer of Mr. P. Sharma, learned counsel for the learned standing counsel
Not
for
standing counsel.
Huh?
Not standing counsel appearing on.
learned counsel for AMDC, respond number 3. List this matter after 2 weeks so as to enable him to file. List these matters, item 10 to 39. Obtain instruction
Yes, sir.
for what?
Up to that instruction, Lordship. And file affidavit also if necessary.
Obtain instruction. According to you, this NOC which you have sought for may not be insisted.
No, the Lordship, the court has suggested that we have the right to check for it in the modified in the interim, but NOC is not required as of now. We have
Once the NOC is issued by the railway,
NOC is issued by the concern from the coal used to come from Nagaland, that part.
concerned state,
Yes,
authority of the state. Once the NOC is issued, it is not required.
Lordship.
Then matter ends there.
No, Lordship, the argument is necessary. Dr. Ashok Saraf is also there in other side, Lordship. Dr. Saraf is also there, Lordship. I have taken consent of it.
So
I have taken consent, Lordship, of this today for today, Lordship.
to obtain instruction and file necessary affidavit. Mr. P. Sharma shall obtain the instruction and file necessary affidavits on or before the next date of listing.
Highly
After 2 weeks.
Lordship, highly obliged, Lordship.
Please, your lordship. With the consent of the other side, I'd like to mention item number 62 of the daily list, your lordship. Item number 62, your lordship.
60?
62.
62. Yes.
Your lordship, in this matter, the respondent number 1 and 2 have filed their affidavit. We need 3 weeks time to file our reply.
Why is this contempt?
Yes, your lordship. They have filed an affidavit.
62.
Yes, sir.
MS S. Sharma, learned counsel.
Here on behalf of respondent number 2.
Learned counsel for the petitioner prays that she may be granted 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the respondents.
DPOB.
What I say?
Yes, Sharma, learned counsel for the petitioner case and may be granted 2 weeks time to file affidavit.
Prays that she may be granted
To file affidavit. Affidavit is in reply to the affidavit in opposition filed by the respondent.
prays aloud. Just after 2 weeks.
DPOB.
Where please, Lordship. Lordship, I like to mention item number 1. In this item, I want to take face step. Face step.
Mr.
Respondent number 6 to 8.
For respondent number 6.
Respondent number 6 to 8.
Mr. Your name, please.
Yes, I see that.
S.H. Sikhdar, learned counsel for the petitioner, is granted further 10 days time to take process steps for service of notice upon respondent number
6 to 8.
6 to 8. List after 4 weeks.
Obliged.
This is very close, please. Admission item 2.
Here, your lordship, I'll seek a small accommodation. Because the petitioner herein is praying for re-evaluation of the compensation amount. That particular compensation amount has been sanctioned. It is in the process of payment. Just that the project director has now sent the proposal for payment to the NHAI regional office. And the regional office, when after it passes, then he will get a payment of 2,28,000. So 2 weeks time will be granted by that.
2,28,669.
69.
So we'll close it.
No, your lordship, there is a.
Lordship may keep it pending for a time being. After
No, no,
2
what is, why, how much he's entitled? Only 2,60,000.
That 20, that 20.
That's all.
No, no, your lordship. 2,60,000 is the principal amount. I am entitled to get the interest. And there is another prayer also, solicium, regarding the solicium. But
Well, let me, she is appearing.
so on 20/11/24, the order has been passed to take the instructions. So
Somebody
let's say
said that
amount.
pursuant to the assessment so made, the NHA is now required to pay soon. Huh? Assessment has already been done. If you are agreed by the assessment, this assessment, first assessment has been in the pursuant to the direction of this court. So,
Person of the direction of this court.
No, only.
So reassessment was done
yes.
and he is about to get about 2,20,000 more. That's why we are
That's
already,
all.
that money has been
No,
already.
there is a question of interest, your lordship. That part
No,
is there.
that-
Because
that-
that-
Before the honorable Singh,
No,
that the
no.
honorable court only considered the
No.
that amount lordship, 2,28,000.
Because it's a case of 2010, now they are paying.
Yes, this it's pursuant to the arbitration.
Yes.
What is your prayer?
Yes,
Direction should not issue direct response to reassess the adequate
Yes.
compensation payable to the petitioner in respect of land measuring so and so. Reassess
Yes.
has been
No.
done.
Here, two parties there, your lordship. If your lordship come to the arbitrator award, your lordship, page 34, your lordship.
Hmm.
Page 34, your lordship.
Yes.
May I read?
Hmm.
Read the appeal petition of Sri Kanendra Chandra Das and Sri Niranjan Chandra Das and Sri Gangadhar Das claiming adequate compensation against their land acquired under NH Act. Are the appellant report received from the competent authority perused? The appellant filed an additional petition during the course of proceeding and report of the competent authority also received against the additional petition. The main contention of the appellants are that the value of their land has been fixed on a lower size at the rate rupees 4 lakhs per bigha, whereas the land nearby Howdy town has been fixed at 12 lakhs per bigha, and they are entitled to higher fixation of their land acquired. The valuation of the building standing on the land acquired should have been fixed at rupees 15 lakhs. After the going through the report, careful consideration, all the relevant record, the following observation.
Come
were
to
made.
page 35. While fixing the valuation of
fixing the
land,
valuation of
solicium
the
and
land, the
other
solicium and
considered
other concerns shall be
direction Mr.
included as per the direction
The
of the state
valuation of
government.
building basis as per market value.
Yes.
Have you done this?
No.
There is no direction regarding a solution or other consideration.
While
That-
fixing
There-
the
there is a
valuation of land, the solicium and other considered shall be included as per direction of the state government. Just wait. This is,
Compensation.
The adequate compensation includes all these two.
No,
Because your
Last
lordship,
hearing was done and
No, no.
lordship honorable court directed to
No.
us to pay the lordship.
while
that
fixing
amount.
the valuation of the land, the solicium, other shall be included as per direction. Where is the direction of the government?
That's
direction is there, your lordship.
Where it is?
No direction regarding that.
As your lordship, under the Land Acquisition Act.
It's not land under the Land Acquisition Act.
National Highway
It's
Act.
under National Highway Act.
Yes.
Yes, but the provisions, they are claiming that the NI Act, the Land Acquisition Act does not apply in case of National Highway Act. But in this
That's
case,
fine.
your lordship, there is a direction of the Supreme Court in one case. May I refer it to your lordship?
Thereafter, what had happened?
Thereafter,
Initially, it
Where
was not
entitled-
applied.
we are entitled to get.
Sir, it was initially not applied. Thereafter, it has been applied.
Yes.
And it has been inserted. The
Yes.
provisions of 2013 Act applies.
Yes.
This
It has
is-
been included. Now, what is your prayer?
Yes, There is
My,
adequate
my
compensation.
prayer is adequate compensation. Adequate compensation means
So
including.
are you
these two-
agreed by the reassessment?
No,
No,
he was agreed to the, before the honorable.
I am
court also.
aggrieved in two aspects. One is Silesium is not there. And
Then-
number two is the building value was less.
Are you agreed by the assessment,
Yes,
reassessment?
No, he was. agreed-
reassessment means only they have reassessed the second part.
And you have accepted the reassessed amount?
Reassessment amount of two parts, second part. That is the valuation of the building.
Hmm.
Valuation in building was preliminary. It is estimated on the basis of the 2004 rate. Now that has been enhanced by the PWD. Page 34, page 44, your lordship.
Last occasion, Lordship, the honorable court directed us to pay the
Last
enhanced amount.
occasion is,
So today the matter has come whether we have paid the compensation or not. Already hearing has been done, Lordship.
no,
Already hearing has been done. After that, the honorable court directed us to pay the compensation. On that, day, Lordship, he never argued regarding that interest solatium. Never argued, Lordship. I was present on that day. He accepted that enhanced amount.
at least I am entitled to get the interest also.
You read the order dated 04/11/2024.
Yes. Compensation directed to pay the compensation.
Right.
No mention of interest, nothing.
At that time only, the amount has to be deposited. The direction is given, the amount
Yes.
has to be deposited by them. So let's the amount deposited and let's it come
Already-
after.
already-
Sir, there is a decision of the arbitrator.
Arbitrator.
Arbitrator has directed to
No,
do something,
This
Do-
is
arbitrator has
Certain-
directed
state government to decide.
two
to
directions.
reassess.
To
Just
reassess.
listen, sir.
No, reassess. is
Sir,
not-
can you listen? Can you hear me for
Yes.
some time?
Yes, your Lord.
Then you are not agreed by that. On the basis of the order of the arbitrator,
Yes.
some assessment has been done, reassessment, which
Reassess-
comes around 10 lakhs
That
36,000.
is only for building value.
We are not concerned. Just wait. Wrongly or rightly, reassessment has been done. You are not agreed by that. Are you agreed by that?
Reassessment regarding the building, we are not agreed.
Doesn't say anything. That's why I'm saying. It's been recorded in order dated 04/11/2024. Where is the award?
Award amount already, initial award amount already we have received. And thereafter, we have gone to the arbitrator for enhancement.
Yes.
And arbitrator has passed this order. Page 35. So here, two condition is there. First
I have
fix-
seen it, sir. I have seen that.
Yes.
What I am asking that wrongly or rightly on the basis of the direction of the arbitrator or the order of the person to the order of the arbitrator, reassessment has been done.
Reassessment,
Forget, just listen. Reassessment has been done. Accordingly, court has recorded that factual thing and directed them to pay the amount which you are entitled as per the reassessment. Are you agreed by the reassessment? Where is the challenge to the reassessment?
regarding the reassessment of the building. This is the regarding building.
Where
reassessment
does
of
it
the
say?
building.
Where is that? Where is the assessment?
Yes, your lordship, come to the page. Page 46, your lordship, my affidavit. Page 49. Page 49.
Hmm.
To the additional deputy commissioner.
Are you challenging this?
I am not going to challenge it, but
Why?
your lordship go through it. Because only the reassessment is regarding building valuation. Regarding reassessment of the building valuation in respect of Khanendra Chandra Das and others. Your letter that suggests us, and the reassessment is done. as-
Sir, very strange. If you are agreed by this, if the arbitrator has directed to reassess, including the solution and other things, other consideration,
That-
and according to you, by this calculation, by this reassessment, only the building part has been reassessed.
Yes,
Are you not agreed by other considerations, including the solution?
that has not been.
Then are
considered.
you not challenging this? Are you not agreed by this?
I'm challenging by filing this writ petition
No.
because they.
Where is the prayer?
There is no prayer. Only reassessment. Adequate compensation.
Reassessment of the education means includes both. Reassessment of the land value, reassessment of the.
Sir, you
building value.
cannot file a petition and throw it to the court
So I.
to determine what is inside, what is here in your mind. Show us any paragraph that you have challenged this, you are agreed by this reassessment.
This reassessment has done after filing of this writ petition.
So,
After filing of this writ petition, they have reassessed.
so you cannot challenge this.
No, I can challenge, I have to file another writ petition.
So
because
you
this-
file who is stopping you? You are only for reassessment as per the order of the arbitrator. Wrongly or rightly, arbitrator has, the authority, the
Arbitrator is. right,
reassessment has been done, right? And accordingly, you are entitled for 2 lakhs something odd amount. So you are happy, you are ready to accept that.
That is the one part, your lordship.
That is the all part. That's not the one part.
One part, your lordship.
No.
It is up to you, your lordship.
Yes,
I have nothing to submit, it is up to you, your lordship.
it's not up to me. It's your case. You have to establish your case.
Then your lordship get me in that some other day, your lordship.
What other day?
Only
Is it not a fact? You have
It is-
brought on record the
it is-
reassessment.
It is a fact of the reassessment is regarding building and reassessment has done by the.
Yes,
PWD.
what arbitrator has directed.
Arbitrator has directed. the
Decided.
Reassessment of the land value,
So they have not done.
they have not done.
Are you agreed or not?
I am agreed.
Then have you challenged that?
That has been, the reassessment is done by, till date I have not challenged.
So if you have not challenged, you are accepting the assessment.
Your lordship. Here, the question is that reassessment has been done by the PWT regarding building valuation. That part is over. But the reassessment of land value has to be done by the deputy commissioner.
That's why
competent authority.
that's why I'm saying.
That has not. been
Only
done
build
till
and
date.
only building, the part of the building has been, so far as the building is concerned, reassessment is done.
Yes,
But the arbitrator has directed to reassess
man of the land value also.
land value also.
Yes.
That has not been done.
That has not been.
So on the basis of the reassessment,
Yes,
they are paying you. They are ready to pay you.
yes.
You are accepting that.
I am accepting regarding the building value.
So far as the
So far the
Solatium
land
and
value is
other land
concerned-
value is concerned, you are not challenging. What they are saying is, pursuant to the order of the arbitrator, reassessment has been done. Therefore, you are entitled this much of amount. You are ready to accept that without challenging the reassessment.
No, regarding building value.
Yes.
I have no challenge.
Yes.
I have no challenge. I never challenge and I. will
What
not
they are
challenge.
saying is you are entitled as per this reassessment only. That is their stand. That's the reason I'm saying that unless you challenge the reassessment, all right, in this petition, you have not challenged the reassessment. Of course, as recorded by this court, you don't, all of you, all even the National Highway Authority doesn't have the knowledge of whether reassessment is done or not. all right, initially. And whether this award has been challenged or not, nobody knows. But by subsequently you filed you brought this reassessment wrongly or rightly. You brought on record, and you are ready to accept the amount which they are ready to pay on the basis of the or as per the reassessment.
But my demand is regarding interest part. is
Your
there.
demand, you have to,
Interest part is there because.
sir,
they
you have
that
to
is-
challenge that.
When, again, I have to file another writ petition then.
We're not here to.
Then the liberty may be given-
We're not here
liberty may be
to.
granted.
We're not here to give you an advice.
Liberty may be granted to file first challenge.
Make a prayer or make a submission.
He had to
As
go
if
to-
you are commanding the court.
No, your lordship. Liberty may be given. your
Sir,
lordship.
have some decorum.
Yes, yeah, oblige
You
your-
appears to be quite senior
oblige
in the
your lordship.
profession.
Oblige your lordship. That the interest
What's
part
the-
is there.
What is this, sir? What sort of submission is this?
উনি কম যে মনে হয় চ্যালেঞ্জ করেন বাস
কিন্তু এইটো withdraw কৰিব লাগিব।
এখন যিখিনি পালে পালে এখন তো মানে
নাই, নাই, এতিয়ালৈকে তো পোৱা
Why not pursuing? I'm just telling you what is the facts in this matter.
All right, your lordship. For regarding the another part, I am going to file another petition challenging that.
What do you want?
Order of payment of this amount because they have not paid till date.
Lordship, the order dated 2011-2024.
Yes,
The honorable court has directed us to deposit the amount.
yes.
Lordship, on that day, he did not object anything, raise any objection regarding this, Lordship. 2011-2004.
You pay this amount.
Lordship, it is in the process. We are a PIO, but so we have submitted all these things to our.
You pay within how many days?
Earlier also we took 2 months, Lordship, at least 1 month.
You pay within 15 days.
What is the position I have, because we are not the. Or they will sell all these things to headquarters, so it needs some time, Lordship, that's why. Already process has been, we have taken the process, steps, Lordship, to make the payment.
Heard, mister. We're disposing of the matter. We'll grant you a liberty. If you wish to challenge that, we'll just give you a liberty. Otherwise, it's disposing.
That is a petition.
Huh?
That is up to him, let him file another petition,
No.
why it should be included in the order. What is it?
Your lordship, pass the order for payment of this amount, SS amount.
That's all.
They have to challenge.
That's
it.
all.
Yes, liberty may be granted.
No, why liberty should be granted? He has no challenge in this writ petition. Lordship. Let him file separate writ petition. In this writ petition, he has challenged only the adequate compensation.
Adequate compensation includes all.
But arbiter has not directed the state government to pay the interest or solution. Let him file, if he wants to file, let him file, why liberty should be given? He is not withdrawing the writ petition. That is the
Not
problem. That he has to withdraw this writ petition. I mean,
Are you withdrawing or passing on merit?
Pass on the rate.
Okay. So we're not granting liberty. It's up to you. Because you cannot have the cake and eat it too. All right. you are accepting the reassessment and
Accepting-
you are ready to accept the amount
Amount
as
of
per
the
the reassessment. And then you are claiming more. You want more.
The interest part is there.
Human need, of course, we understand human needs it unlimited.
Interest part is there, your lordship.
Will not say anything. Heard Mr. N.N. Upadhyay, learned counsel for the petition, and also heard M.S. Arbora, learned counsel for all the respondents. 1, 2, 6, and 7. And 1, 2, 6, and 7. 1, 2, and 6. 1, 2, and 7. Then, Hmm.
I'm
Hmm.
for 4, 5, and 6.
I am for 8.
Okay. Anything you want to submit? Okay. Next paragraph. By filing this writ petition, the petitioner has sought for a direction to reassess the adequate compensation in respect of the land measuring 2 kathas 3 leches covered by DAG number 2 within bracket part dash KP Patta number 28, village Itarbata, Moja Gilajari, in the district of Barpeta. And the land and the building in terms of the order dated 07-10-2013 passed by the Commissioner, Lower Assam Division, Guwahati in arbitration case number 56/2011. Please stop. The petitioner was initially awarded a compensation of rupees 9,79,314 for the land land and the building for the land and building of the petitioner. Please stop. Being agreed, the petitioner approached the authority accordingly. And in the arbitration case number 56 of 2011, the arbitrator observed that the land and the building were valued on lower side, and accordingly direction was issued to redetermine the value of the land and the building by the order dated 07-10-2013, including the solicium and other consideration as per the direction of the state government. Please stop. Thereafter, Additional Deputy Commissioner, being the competent authority under the Highways Act on by order dated 02/05/2015, requested the Executive Engineer, Nalbari, to redo the assessment of the building. Mr. Essentially, this writ petition is being filed for adequate compensation in terms of the arbitration order dated 07-10-2013 was in arbitration case number 56 of 2011. List of. During the pendency of the writ petition, the authority by calculation by dated 28/06/2016. When this writ petition was filed?
Sixteen.
18 May.
May.
28/6/2016, huh? The executive engineer, PWD, Nalbari Building Division, has reassessed the compensation, reassessed the amount of compensation to be paid to the petitioner. List of accordingly, an amount of rupees 10 lakhs 36,000 has been reassessed. It is reassessed for payment of compensation to the petitioner. List of. This court on 04/11/2024, taking note of such reassessment, granted the respondents to apprise the court as to when the amount so assessed would be paid to the petitioners. List of. Accordingly, the learned standing counsel appearing on behalf of National Highway Authority of India had apprised this court that pursuant to the reassessment so made, the National Highway Authority of India is now required to pay an amount of rupees 2,28,669, which would be paid to the petitioner within a short time. And this court has directed to take appropriate steps for disbursing the same to the petitioner. List of. Today, Mr. N.N. Upadhyay, learned counsel to the petitioner, during the course of hearing, made a vain attempt to submit that the reassessment so made is only in respect of building, and the entitlement of the petitioner in respect of solicium and other consideration as directed to be reassessed by the arbitrator has not been done as yet. Therefore, he submits that the petitioner is entitled to a compensation of the land, including the solicium. List of. Next paragraph. MS R. Bora, Learned Standing Counsel for National Highway.
Che.
National Highway Authority, after that you say in short NHA. NHA, huh? Upar, huh? Beginning. NHA submits that the amount of rupees 2,28,669, which is due to the petitioner pursuant to the reassessment as per the order dated. What is that orders?
2020.
07, no, 07. Order of the thing. Page 07-10-2013 of the arbitrator. And same shall be released within a period of 1 month from today. Christoph, next paragraph. Perusal of on consideration of the submissions as well as the materials and the grievance raised in this writ petition, comma, it transpires that the petitioner has essentially sought for an payment of compensation in terms of the arbitration award, arbitration order, in terms of the order dated 07-10-2013, 13, passed by the Commissioner, Lower Assam Division, Guwahati, wherein a direction was, a decision was, an observation and a direction was made to the extent of, to the extent that the, while fixing the valuation of land, the solicium and other considerations shall be included as per the direction of the state government, and the valuation of buildings be assessed as per market value as on date of taking on possession of the acquired land. List of by providing the specific date of taking over to PWD within bracket, capital B bracket close. List of it is on the petitioner has brought on record the reassessment dated 28/06/2016 by the Executive Engineer, PWD, Nalbari Building Division, Nalbari, whereby the an amount of rupees 10,36,000 is found to be entitled for compensation to the petitioner. List of why only 2,28,000? It's deducting the earlier award. I mean the amount which you.
Yes, already they have paid.
List of
8 lakhs,
8,07,300.
7,000 we have paid.
okay. List of it is also noticed that no, it is stated at the bar that the petitioner has already been received, paid and received an amount of rupees
8,07,300.
8,07,300
300.
out of total reassessment amount of rupees 10,36,000.
Yes.
And now the remaining amount of rupees 2,28,669 is to be paid to the petitioner which the respondent authorities have categorically stated, has agreed and accepted that same shall be disbursed within a period of 1 month. This stuff. Next paragraph. Although the petitioner, the learned counsel for the petitioner, as noted above, submitted that the reassessment is only in respect of land and no reassessment has been made so far as the compensation for land is concerned, I'm of the view that on consideration of the pleadings, I'm of the view that no challenge has been made, or for that matter, no grievance has been raised so far as the reassessment dated 28/06/2016, even after even after bringing the said reassessment on record in the present proceedings, Mr. Does the issue which had been attempted to be raised cannot be considered in this present proceedings, as no pleadings or prayer has been made for such issue, Mr. And as such, the submissions made by the learned counsel for is not accepted, Mr. Next paragraph. Considering that the petitioner is willing to accept the amount of reassessment which has been done by the respondent authorities pursuant to the order of the arbitrator dated 07/10/2023, I am of the view that no further consideration is required to be made so far as the reassessment is concerned, as no challenge has been made. Rather, the petitioner has willingly ready to accept the has accepted the amount and the reassessment amount. Willingly accepted the amount of rupees 8 lakhs something,
Not it.
and also ready to accept the balance amount of rupees 2,28,669 in terms of the assessment made by the authorities pursuant to the order of the arbitrator dated 07/10/2024. In view of the above, the writ petition stands closed. Mr. Hauba, in view above, the writ petition stands closed with a direction to the respondent NHI to disburse the balance amount of rupees 2,28,669 to the petitioner within a period of 1 month from today. The petition stands closed.
Item 3.
Yes.
In this matter, madam, we have island IA. Lordship,
For what?
For implement of PWD rules as a party respondent. The PWD rules is the acquiring authority.
So what do we want? It's 2017 matter.
Lordship, we have filed, Lordship, may I pray that this IA, filing number 3190 of 2025, may we come up along with the petition.
On the strength of development may be completed. When was the proceedings carried out?
Lordship, long back in
Huh?
Yes, Lordship. It was 1314.
Where you were? When was the land acquired?
Lordship, survey was not properly conducted. my
No,
lord.
no, when it was when the acquisition was done.
Lordship, it was the acquisition for National Highway 52B from Kanubari to Borborwa.
When? Which year?
Notification was issued in the year 2008. 2008.
So you have
Subsequently-
filed this writ petition?
Lordship, subsequently, survey was conducted during 1314.
Hmm?
1314. Survey was conducted during 1314.
Okay, initiated in 2008 and
Notification-
surveys was conducted in 2013.
Lordship, 9 to 1314.
Okay, so
That during that period, that
your land has been acquired.
acquired without properly survey.
So you are not agreed by the acquisition. You want the enhanced compensation. Have you been paid the compensation?
Lordship, as survey was not properly done, our compensation is pending.
Hmm.
That's the case.
Road has been constructed. National highway.
We have paid that in affidavit, we have, if everything has been stated, there are and land corporation are already been paid.
Okay.
But some of the petitioners who are smaller that occupying the government land,
Hmm.
so they are not entitled, so we are not giving them.
Zirat is entitled for Zirat, Lordship. They are entitled for Zirat.
You are only claim for Jirat.
Lordship, that is the, it will be clear from the.
Anyway, he is filed in MS so-and-so learned counsel for the petitioner submits that she has filed an interlocutory application for implement of
PW routes.
PWD
routes,
roads, Assam.
Dibrugarh,
Assam PWD roads. Assam.
Assam,
PWD road.
and PWD, Dibrugarh division. PWD routes, Dibrugarh division.
No, for implement of, seeking implement of the respondents in the Department of PWD road, Assam. This stuff. When you have filed already.
Already filed. Filing number is
Mr.
3190.
However, the same is not listed along with the same is not listed with this with the writ petition. Therefore, President, this matter may be listed along with the IA
IA filing number
accordingly. No,
3190.
please stop. Prayers allowed. List the matter after 2 weeks
Along with IA.
along with IA, which stated to have been filed.
Obvious.
Item 4. Okay, in this case,
Lordship,
similar issue already.
my senior is on legs, your lordship. It may be taken up after some time.
So it's a covered case.
Lordship, she's there in the court.
of it's already disposed of by his husband.
Hmm.
Only this case left on also.
Lordship,
From
she's,
that series also. There are 2 series have been disposed of by that husband. You can have a look at husband. That is the WBC.
One third traders in another. It's already some here.
Yes,
It's only in the record.
yes,
So what is to be done?
yeah, dispose the same.
Lordship,
Similar issue.
she's there on legs only.
Last occasion also.
after
that
some
comes on only this.
Just sometime, lordship. She's there in court 20 on legs.
What is there? It's been allowed.
It is on disposal of this.
Court is not inclined to present the responsibility
paragraph
corresponding board of the
Can I have
SSS.
paragraph number?
So it's against her, against the petitioner. Yes,
May I please, your lordship?
covered case.
Yes,
Okay.
covered, but lordship, there is.
No if and buts if it is covered.
Lordship,
Either it is covered or it's not covered.
lordship, I may submit only for 1 minute. Lordship, it is covered by the
You may
judgment.
submit for 1 hour, no issue. But
No,
then
no,
if it is covered, either it is covered or it is or it's not covered.
Lordship, I will require only 1 minute, lordship.
We cannot modify.
No modification. I
Yes.
don't want any modification, lordship,
Then-
in the order. But there is a difference only in facts, lordship. Lordship,
Obviously, different facts will be different.
see this is what they are saying, that this is covered by the.
This was disposed of, this is of disposal.
What series? I have to have a copy of the order. He is always misleading, Lordship.
I am not misleading, Lordship. That is the.
Always misleading, always,
No,
Lordship.
Lordship,
I'm
what
making a
is
statement that must be
submission?
recorded.
What
That
is
must be
submission?
recorded.
Kindly record it.
That must be recorded.
In this
Always misleading, Lordship.
Lordship, this case is 465718 and that case is 4727. Same series, Lordship. I am not.
Madam, you tell us it's covered case or not.
Yes, your Lordship, it's a covered case.
Then
Lordship,
matter ends there.
Lordship, may kindly see.
You'll be provided same relief.
Lordship, the same relief because Lordship may kindly see what is the judgment. Lordship may kindly give me only 1 minute. I will inform your Lordship what exactly is the only difference. The judgment, so far as law point is covered, it is covered. Lordship.
Yes.
Law point, it is completely covered.
Yes.
So far as final Lordship may kindly see. Wait,
This Butter case.
Lordship, the
Butter
judgment is.
traders.
Butter traders is not giving me copy. I don't know.
He sees the.
But the traders.
petition of-
Ah.
But the traders.
For both cases, both
But the
cases,
traders, I am saying that it is covered.
Lordship,
Yes, then-
4727.
Lordship is not allowing me to even speak a single word. It is his submission that it is covered by Bhatter traders. I am relying on Bhatter traders stating what is wrong with you. Let me submit.
Okay,
Yes, yes, yes.
Please sit down.
I am not sitting on your direction.
But I have to submit.
Okay, submit it.
It's okay, madam.
Lordship,
Carry
may
on.
kindly see that, Lordship, the final judgment, which is paragraph 23, is the Lordship final judgment. He has submitted, Lordship, that this is covered, and I'm saying that it is covered, but I'm just. Lordship, para
No,
22
no,
is the.
madam,
para
this is the
22 is the-
problem. If you are saying that it is covered, why you have to make a
Lordship,
submission?
because the judgment is in two parts. Lordship, may kindly see paragraph 22. Paragraph 22 is the judgment,
Page,
page 31. Page 31 of the day, it does, Lordship. Lordship, may I read? Para 22, page 31. Lordship, the law, if applied to the facts of the present cases, would make the exemption so granted by notification so and so, issued by so and so, issued by finance department in respect of service by any agricultural produce marketing board or service spread by commission agent for sale or purchase of agricultural produce presupposes that the cess which was collected by virtue of so and so has been subsumed by CGST as well as AGST Act. Under such circumstances, levy of cess by the respondent board of market committee after the said notification had come into effect was unconstitutional as well as ultra virus to the provisions of CGST Act, AGST Act. This is the Lordship judgment. That the entire Lordship, the act was ultra virus and all the levy has gone. So levy has gone. Thereafter, Lordship, the court has decided on that whether after the court has decided that the levy was unconstitutional, the court has further gone on to decide whether the petitioners are entitled to refund. Lordship, Lordship may kindly see paragraph 23. The court has said that, Lordship may kindly see the fifth line from the above. From a perusal of the writ petitions, it revealed that petitioners are in the business of resale.
where it is?
Para 23, Lordship. Para 23, 4 lines from the above.
To decide the second aspect.
Second
Huh?
aspect, Lordship. Second, to decide the second aspect of the matter, it would be relevant to take into account the pleadings of the parties before this court. From a perusal of the writ petitions, it revealed that the petitioners are in the business of resale and for the purpose bring materials from outside the state of Assam. So, Lordship, this is a reseller. The petitioners before this court were resellers. That is why, Lordship, the court has declined to grant any refund. I am a manufacturer. Lordship may kindly see, I am also not asking for refund. Lordship, if he is mistaken that I'll be asking for refund, is predetermined. Lordship may kindly see paragraph 28. The court has rejected the refund after going through all the judgments. In the said judgment, reference was also made to the judgment of 9 judges of the Supreme Court. In the case of so-and-so, it was observed by the Supreme Court that the claim for refund can only succeed if it is alleged and proved that the person from whom the tax was illegally collected had not passed on the burden of the duty to another person or other persons. In the instant case, there are no averments made in the writ petition that the goods which have been bought for resale, burden of sales were not passed on to the customers of the petitioner. Under such circumstances, the question of amount collected from the petitioner as assessed during so-and-so to be refunded to the petitioner does not arise. So, Lordship, it was a case where the refund was rejected on the ground that I have not, whether I have passed on to the customer or not, because resale is there. my only lordship submission is that the second part of the thing, we will file a refund application before the authority. Lordship, on the basis of this judgment, because now they are agreeing that cesses should not have been levial on me. So Lordship, I'll file a refund application. If they find I am entitled to refund on the basis of this averment, that whether I have passed on to the customer or not, well and good, otherwise they may reject. I am only asking for only this accommodation, nothing else. At Rule 23, Lordship, there is a provision. that I
According
can-
to you, since in the Butter's case, since there was a resale,
Resale,
therefore it was not been allowed.
not been allowed.
You are a manufacturer,
Manufacturer,
so we'll not go into that.
but-
That's why I said indicated, if you agreed that this judgment is covered your
Covered,
case, nothing
covered.
else, we'll provide that one page order. We'll say that this is covered by this.
Lordship, may kindly quote the entire judgment and Lordship then may pass the order. Lordship, the relevant paragraphs, Lordship, I may be, Lordship,
What relevant paragraph, what's there?
Lordship, from paragraph, Lordship 15 onwards, relevant paragraphs. Lordship, may kindly quote the entire the. From paragraph 15, Lordship may quote the entire judgment, Lordship, till the end. And Lordship, my prayer only would be that since only one consideration may be given, that I may be allowed to prove before the authorities that whether I have passed on the burden to the customer or not. That is the only. From paragraph 14, the 15th Lordship, the Supreme Court Lordship constitutional bench judgment has been considered.
Have a look this order, 9/2/2024. After passing of the Bhatta Readers, this order has been passed last week. The same dates of restriction.
He has not given me a copy, Lordship. He has not given me a copy. I don't know
Lordship,
about-
she is the counsel in that case, Lordship.
Which case, I don't know. He's not even.
Lordship,
given
kindly
me a
have a
copy.
look the counsel who appeared in this, on that.
Give me a copy. Give me a copy of that.
Yes, I know. আপোনাৰ মানুহ আছে। আপুনি জানে নহয়? 4727 নহয়, single bench. There was that. Also, kindly have a look the 4727 as well. Order dated 9/2/2014. Same dates of advocacy there also. The two beds of request has been disposed of by this honorable by coordinate bench Lordship.
The same judge, Lordship.
Yes, financial condition.
Their financial condition is poor, Lordship. This is what they have stated. I am just saying that, Lordship, I'll file a refund application. If they find that no, they may reject.
No. It cannot be allowed. Huh? We'll pass the similar order.
Entire paragraphs of.
We'll see.
To pass it,
Lordship.
order like 4727.
MS and Haveli, learned counsel for the petitioner. And also her.
तुमसे को हुए और समीक्षा रहेगी सर मार्केटिंग में।
I'll pass the order. Similar order, I'll
Similar
pass.
order.
I'll go through the judgment.
Lordship,
It will take time.
That was only my Lordship request. Otherwise, Lordship may
But
pass the same order.
that is rejected in view of the order passed. Because where you are admitting and agreed that it
covered.
covers.
It's a covered case.
So
There is no-
whatever the
only the-
observation and whatever direction will also be covered.
Only that was resale. This is manufactured. That's the only difference. Otherwise, the entire thing is covered.
We'll record the facts.
Much obliged. Much obliged.
But
Lordship.
your prayer is rejected.
Highly obliged.
Lordship, but finally my case is allowed. Because the cess is gone.
Yes.
Yes, your Lordship. Much obliged.
That is called balanced justice.
Justice, Lordship. The case is in my favor, but finally refund is not granted, whatever has been paid. Anyhow, Lordship, I was enjoying the stay. Much obliged, Lordship.
Kalpatru Eglo. Yes, what is this?
The writ petitioner had booked certain assignments, that is containing bamboo craftsmen from New Bongaigaon to Amlai. Now, they carried, the railway authorities, my lord, carried it, but in nutshell, the matter is like this, my lord, they carried through a longer route. Thereafter, they carried it to a shorter route and charged, freight charge
For a longer route.
longer. Then I paid for a refund that were rejected. Then I came to this on the court. No, I paid for refund that was not allowed. This on the court has said, no, they are entitled on appeal. Thereafter, I went for execution. Before the executing court execute it, the railway authority again passes an order saying that, no, you are not entitled. That is how I'm.
Let's see the order.
The railway's order is just
No. Appellate order.
High Court order, yes. It starts from page,
Single bench rejected.
no, it was appeal, ma'am. Statutory appeal.
Acha,
Page 28 is the order, ma'am.
page 28.
My lord. Tribunal, another person.
Yes.
Rejected. Then against that, I came on appeal before the Honorable Court. This is the order passed by the appellate court. This Honorable Court in appeal under section 23 of the Railway Claims Tribunal Act.
Okay.
Page 28, I am reading you, Your Lordship. These appeals under section 23 of the Railway Claims Tribunal Act 1987 are directed against the common order dated 10/8/2001, passed by the Railway Claims Tribunal Guwahati in claim applications number so, rejecting the claim for refund of the excess freight charged from the appellants by the respondent railway for carriage of the goods booked by the appellants. Since all the claim applications were rejected by the common order and the common question of law is involved, the appeals are taken up together for hearing and disposal as agreed to by the Land Council for the appearing parties. The appellants filed this aforesaid claim application before the tribunal claiming refund of the freight contending inter alia that certain goods were booked for transportation by railway from one station to another, for which freight was charged for a distance between the booking station and the destination station to the longer route, though carried in a shorter route, and as such they are entitled to refund of the proportionate freight. In appeals case number so, the claim of the appellants before the tribunal was for refund of the freight amounting to rupees 57,000.
These are all your case.
My lord. All our.
It's for you.
Yes,
These claims by you. All these claims are by you.
by me.
Okay.
So it was rejected. The contention of the appellants was that the bamboo carts were booked by different railway receipts on different dates for transportation of the railway from New Bongaigaon to Amlai, for which though the railway has charged the freight taking distance between two stations as 1769 kilometer via MLDT. MLDT is Malda station, which is a longer route. The goods were transported from New Bongaigaon to Amlai through a shorter route via Andal, Anara, Chakradharpur, covering distance of 1510 kilometers. And as such, they are entitled to refund of the excess rate charged by the railway for transportation of the aforesaid goods. The contention of the railway in written statement filed before the tribunal was that the freight for transportation of the aforesaid goods from New Bongaigaon to Amlai was charged under the classification 145 at the rate of 67.40 per quintal under the provisions of station to station rate as empowered by section 32A of the Railways Act 1989. And hence the appellants cannot claim refund on the freight on the ground that though the freight was charged on the basis of distance to be traveled between the two stations to a longer route, the goods were carried by a shorter route. The tribunal has rejected the applications filed by the appellants claiming refund of the proportionate rate of by accepting the contention of the railway and hence the present appeals. I have heard so and so. Next paragraph, my lord. It has been submitted by Mr. So and so Learned Counsel for the appellants that under Rule 125(1) of Goods Tariff Rules 1992, the railway administration is obliged to carry the goods from one station to another through the shortest route in the absence of any specific.
Yes, where is the final direction, final order?
My lord, lords may just have a look at the question which was framed. That's for that just small paragraph, page 32, my lord. Paragraph 10. The question which requires for determination in the present appeals in view of the aforesaid undisputed facts is whether the appellants are entitled to refund of the proportional rate charged and realized from them under station to station rate for carrying the goods from New Bongaigaon to Amlai by a shorter route, namely by a so and so. Now the answer your lords will find. Page 34, para 14. In fact, my lord, these discussions of these rules and the provisions are prior to that. In the instant case, the goods were carried from New Bongaigaon to Amlai via Andal, Andhra, Anara, Chakradhar. Though in the RR, it has been mentioned that goods would be carried from New Bongaigaon to Amlai via MLDT, the distance of which is approximately 1769 kilometers.
What is RR?
RR, railway receipt.
Okay.
There is also an endorsement in the said RR that the concessional rate pursuant to the notification dated 2/9/1993 is applied, meaning thereby that the concessional station to station rate as notified by the NF Railway wide notification dated 2/9/1993 has been applied. There is no written instruction from the sender or his authorized representative to carry the goods from New Bongaigaon to Amlai via MLDT, which is a longer route in comparison to the distance between the New Bongaigaon to Amlai via Andal, Andhra, Chakradhar, through which route the goods were in fact carried. The note relating to charge of the freight on concessional station to station rate was put by the railway administration in the RR and not by the sender. In the absence of any such endorsement in writing in forwarding note for carrying the goods by other than shortest route or the cheapest route, the railway administration is obliged to carry the goods by the shortest route at the charges by the cheapest route as required under Rule 125(1)(b) of the 1992 rules. In the instant case, it is not in dispute that though in the RR it has been shown that goods will be carried from New Bongaigaon to Amlai via MLDT, those were carried to the destination station via Andhra, Andal, Anara, etc. The freight, however, was charged on the basis of station to station rate pursuant to notification date so and so. Nothing could be placed before the tribunal or this court by the railway administration to demonstrate that the central government has issued any special or general order as required under section 171(1)(b) of the 1989 Act, specifying that the goods can be carried and charged by a route specified therein, so as to deprive the sender from the benefit of provisions contained in Rule 125(1)(b) of the 1992 rules. The plea taken by the railway administration that since it has the power under section 32A to charge freight on station to station rate, and as such charge, the appellants would not be entitled to refund of the freight even if the goods are carried by a shorter route, cannot be accepted in the instant case. As such, station to station rate cannot be more than the freight to be charged for carrying the goods by the shortest route, thereby compelling the senders to book the consignment at a much higher rate by the railway, more so when the route in which the goods were to be carried, though has specifically been mentioned in the RR, that is by the longer route, the goods were in fact carried by a shorter route. It would have been different had the railway carried the goods. Then, my lord, will kindly see just paragraph 16, 2 lines. In view of the aforesaid discussion.
No, that I have seen.
Yes.
Then what happened?
Then when we approach we file the application for execution, during the pendency of that, the railway said issued this letter, page 37. In the subject case, the Honorable Guwahati High Court by its order dated so and so, para 16 has discussed as follows. Para 16 is quoted here. Then this last paragraph, my lord. The matter was examined by the respondent railway and has come to the conclusion that freight chargeable via Andal, Anara, Chakradhar under station to station rate has been rightly calculated.
Nothing is
And nothing
refundable.
is refundable. Meaning thereby, my lord, the stand which they took before the tribunal, which has been rejected by this honorable court, they are again sticking to that. And now they are given an example, and then they say you are not entitled to anything. This example, they have given an illustration. Had the consignment booked under normal rate, example, invoice number so and so, chargeable weight 1320 quintal, rate per quintal 79.56, route via Andal, Andara, Chakradhar. Therefore, freight should be rupees so and so. Under station to station rate, example, invoice number so and so, chargeable weight 1320 quintal, rate per quintal 67.40 per quintal, freight should be so and so. In this case, the freight was calculated according to the STS, that is station to station rate, rupees so and so, which is special reduced rate, and this has been worked out as per the shortest route. In view of the above, the claim in the subject cases are rejected and treated as disposed of. Thereafter, my lord, on the basis of this order passed by the railway authorities, the tribunal has passed the last page order on page 39. In view of the aforesaid order passed by the chief commercial manager, no orders are required to be passed. So in the executive court has not undertaken any exercise, but however, applicant is at liberty to seek redressal of its grievance in the appropriate forum if not satisfied with the order of chief commercial manager. Execution petitions stand disposed of accordingly.
This chief commercial manager NF Railway, this order is appealable.
This chief commercial manager? No, madam. Yes.
Is it not?
No, it's not appealable.
He said yes.
No, there is nothing in the law which provides an appeal against order passed by chief commercial manager.
May I?
Yes.
That order would be challengeable by way of an original application before the tribunal. No, appeal would not lie. My case before this honorable court is that this writ petition is not maintainable at all. If
No,
the-
see page 35. What is the order of this court? Railway administration directed to work out the freight chargeable at the relevant point of time for carrying the goods from New Bongao and Amalai.
In which route the goods
Route
were
the
carried.
goods were carried
And
and to pay the appellant the difference, if any of the so and so.
Pursuant to this.
Because
order-
all your the submission was rejected.
Hello. Pursuant to this order of this honorable court, my lord, rightly or wrongly, the railway authorities had passed an order. Now, being aggrieved, they file an execution petition before the London Railway Claims Tribunal. That execution petition was dismissed, my lord. Against that order, an appeal lies before this honorable court under section 23 of the Railway Claims Tribunal Act, my lord. This writ petition is not maintainable at all.
Against the order of
Rejecting the execution. And if they are aggrieved by the order passed by the administrative authority, that is the railway authority, they will have to file an application before the railway claims tribunal by way of an original application.
So he has two remedies. Against the order of the railway authority as well as the order of the tribunal.
Tribunal. And the act itself provides that remedy, my lord. That provisions of the act cannot be bypassed, my lord. That is,
Otherwise, by this order of this court in the appeal,
my lord,
it's clearly
there is a direction to calculate, but rightly or wrongly, my lord, I am not on that, my lord. They have decided, my lord. Now, if they are aggrieved, my lord, they will have to file an original application against that order, or if they are aggrieved by the execution order, my lord, rejecting the execution petition, they will have to file an appeal before this honorable court. If I may take your lordship to the provision to the Railway Claims Tribunal Act 1987, my lord. Section 13 says about jurisdiction, my lord.
come to the relevant provision.
My lord, then section 22 and 23. execution of orders of claims tribunal.
An order made by term civil and is shall be executed by the claims tribunal as a decree of civil court and. Huh.
Then section 23 is relevant, save as provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure 1908 or in any other law, an appeal shall lie from every order, my lord. This word is important. From every order not being an interlocutory order of the claims tribunal to the High Court having jurisdiction over the place where the bench is located. So this is an order by the tribunal rejecting the execution petition.
What is the provision for filing?
Section 16 and jurisdiction, my lord, is provided under section 13.
Application to claims tribunal. Yes, sir.
Well,
It
my-
appears he is correct.
No, madam, it's not correct. Lordship will kindly see what has happened here is, so far as the dispute between the parties is concerned, that has been adjudicated by the Honorable Court in appeal. So on merit, there is nothing more or there is no requirement of again adjudication. Now, when we go before the executing court disposes of without taking any decision on merit whether the decree is to be executed or not. Nothing has been said. It is only saying that railway authorities have taken a decision.
Decree is the ordered in the, appeal. What is the decree?
Decree is the order passed in this.
In this appeal,
In the appeal,
under section 23.
23.
Okay.
So that is there. Now, when the railway authority again passes an order, that has got nothing to do with the merit of the case because adjudication which has taken place already. Now the railway authorities cannot go beyond that, saying that no, I will not comply with that order. The order which has been passed by railway authorities now is practically against the order passed by the Honorable Court. They have taken a decision on merit again. I am agreed by that. So far as executing court is concerned, executing court has not decided anything on merit. That will not decide your execution petition.
No, if the executing court has to execute the decree
Yes, madam.
passed in this appeal,
My lord.
the way he should rely on the order passed by the railway.
That is what
So
I'm
that
saying.
is applicable under section
No,
23.
my lord. That is not an order passed on merit of the execution petition. He is not saying that in the execution petition for this reason, it is not executable. What he is saying is relying on the order passed by the railway claims tribunal. What is coming in my way is the railway authorities fresh order, which is just contrary to the order passed by this honorable court. This honorable court has specifically decided that your plea.
The railway administration is directed to work out the freight chargeable at the relevant point of time for carrying the goods from New Mongangai to Amal so and so. The railway administration has been directed.
Yes, now they have to work out. And while working out, they are now saying something against the order passed by the Honorable Court. That is my grievance before Lordship, madam, today. Because, madam, I'm just
Heard Mr. D. Majumdar, learned counsel for the learned senior counsel assisted by D. Chaudhary, learned counsel for the petitioner, and Mr. B. Sharma, learned standing counsel, CGC, senior railway. I've heard the learned counsel for the parties at some length. List after 2 weeks as part heard. I'll go to work to it.
yeah, if necessary, I'll make.
I think this the direction in the appeal is to the railway administration.
Exactly.
Wrongly, rightly, if the railway authority passes an order, I think prima facie, he may be correct. Can you, I'll hear you
I'll
on next day,
I'll
but
make
let
it.
me go through.
I've got the
I'm just indicating.
Because my lordship will kindly see one
Because
thing,
direction was told
if
to the railway administration.
to work out.
Wrongly, rightly, they have kind.
No, if they work, my lord, one suggestion.
And the execution code on the basis of once it is, if the railway authority passes wrongly or rightly, if it is not executable in view of that order. Suppose if the railway administration has
Not passed any.
decided that you are not entitled anything.
Yes.
What's the question of execution? So maybe the execution court was
If while working out in terms of the direction passed by the court, they find that I'm not entitled to anything, then matter will end there. I maybe I have to start a fresh exercise by filing an application before the claims tribunal. But here is a case, they are not working out. They are again sticking to their original stand taken in the written plea. That is what I will submit, my lord. They are again taking the same plea of station to station rate, which
no,
they
anyway, that same plea,
Yes.
wrongly or rightly, is it not appellable order?
No, my lord, that's what I'm saying. That means, my lord, every time your lordship decides, I'll go to them. They instead of paying that, they will again take a decision on the same line. Then again, I'll have to go file an application. It will be never-ending process.
So it will be again appeal from Caesar's to Caesar's wife. Round and round.
Round and round.
Jalebi.
So yes.
Jalebi is not good for health nowadays. We'll see
My lord,
after 2 weeks.
my lord, would your lordship like to give a fixed date? So that
This is of 2017,
Yes.
18.
since it is part
Fix
of,
that after 2 weeks. Make it 3 weeks.
as your lordship.
Okay.
Item 6.
Lordship, in this matter, senior counsel, B doctor is appearing, Lordship.
So,
So he is on Lakes, Lordship. Hey, password for
what is the matter?
Judicial matter, my lord. They are enjoying a stay in this matter for the last 5 years and more. And
He is on Lakes, Lordship. I am paying for a time being, Lordship.
Today may not be possible.
some urgency, if your lordship takes.
No, I understand, but may not be possible. Bro. It's supposed to arrive at 1:50.
Item 7.
Jitin Das.
Your lordship. It's a writ petition filed for transfer of 2 FIRs from state police to CBI, your lordship. Your lordship, the case.
What's the case diary?
My lord, case diary was called for. Now, Lord, I have not received the case diary, but I have received the latest status report from the SP, CID.
Saying what?
My, last 3 month person may be seen, there will be available. Now, earlier it was investigated into by Jalukbari police station, and subsequently it has been transferred to CID Assam. Now, some witnesses are again instructed to appear before the IO for their re-examination.
When is since pending, since when?
My lord, it is a long pending case.
2018,
Actually, the
yeah.
occurrence took place in 2018,
18,
no?
yeah.
2018.
So it still appears to be on the investigation is in the initial stage.
No, my lord, the investigation was done, my lord. all efforts were done, made by the previous IOs, but his whereabouts could not be, even without many dead bodies were examined, seen, checked out, whether the missing person belongs to that, those dead bodies.
What is your prayer?
Your Lordship, my prayer is that to transfer this case from state police to CBI, Your Lordship, not as cases under CID, Your Lordship, but it will transfer to CBI, Your Lordship. Because two
It's
status-
under CID.
Yes, under CID to CBI.
Why it should be sent to
Because,
CBI?
Your Lordship, two status report was provided, Your Lordship, furnished to me, Your Lordship, wherein they stated that they have searched one at Swalkushi River Police, Your Lordship, whereas there are 4 river police and 6 river police outposts, Your Lordship. That all were not searched, Your Lordship. And here, Your Lordship, 3 accused persons' name has been mentioned. Your Lordship, Robin Soikia, respondent number 9, 10, 11, Your Lordship. Only one person was
He is also
inter-
examined, that Robin Soikia is also examined.
only one
Nothing could be
person,
found
Robin
out.
Sarkia, was only interrogated, Your Lordship, but Amrit Bora was respondent number 11 was not interrogated, Your Lordship. And Your Lordship, when IO was there, he was called upon twice, Your Lordship, but he didn't turn up and didn't submit any statement, Your Lordship,
But may I
regarding
suggest one
the
thing, Milord?
investigation, Your
Let me
Lordship.
have 3 weeks' time. Let us see what progress could be made by the CID subsequently, Milord. Regarding investigation, Milord. Let it come after 3 weeks, I'll produce the case.
Let us do one thing. You now next date, case diary along with the
Yes,
status.
yes.
All right. Heard MS so and so learned counsel for the petitioner. This court on 05/03/2025 directed Mr. Das learned additional PP to produce the case diary, considering the nature of the grievance raised in this writ petition. Mr. Today, Mr. Das, learned APP, placed the correspondence, compressed the communication dated 11/03/2025, indicating the status report in connection with Jalukbari PS case number 1768 of 2018 and case number 1510 of 2018. Mr. On the prayer of Mr. Das, learned this PP. This matter after 3 weeks for production of case diary along with the status report of the case.
Yes, may I go to the status report?
It's okay.
Number 8.
Since you are fixing after 3 weeks, okay.
Madam, this report will form part of the record, you know.
The copy of the communication dated 11/3/2025 is kept on record as and marked as document X.
Obliged. So no date is fixed, I think.
Hmm?
Whether any date should be fixed or.
2 weeks.
After 3 weeks, he gives that.
Can it be on any other bill? I have taken the consent, Your Lordship.
What is the matter
But it's regarding an illegal construction, Your Lordship. Illegal construction
of what?
of a building, their building.
That is not correct, my lord.
Brothers,
No, no. I am respondent 6, madam.
real enemies,
Neighbor.
neighbors,
Can it be
on the prayer of Mr. So and so learned counsel for the petitioner. List this matter after 4 weeks.
Can it be on 2nd of April, Your Lordship?
4 weeks.
Value.
No, and prayer not being, only prayer of so and so and the prayer not being objected to, and consent for the respondent. List this matter so and so.
Item 9, Lordship, I need some more time, Lordship.
Why? What is the matter?
Demarcation matter,
Demarcation.
demarcation of the land.
Simple matter, demarcate it, what's there?
Yep,
Heard Mr. So and so, learned counsel for the petitioner. Mr. J. Hendrick, learned state counsel
Lordship,
for respondent number
1 to 5.
1 to 5. Fresh for and is granted 2 weeks time. 3 weeks time.
2 weeks.
Please stop. On the next date, it is expected that by the next date, it is expected that the authorities shall consider the case of the petitioner by demarcating the land as sought for in this petition. Yes,
Lordship.
within 3 weeks, making
Okay,
demarcation
I will
so that we
demarcate.
can close on next day.
Okay.
Unnecessary.
Obliged.
I think noted.
40.
I am for respondent number 2 and 3.
Yes. 40.
40.
What is the matter, sir?
So there was cleaning of river undertaken in the Barak Valley, Barak River. That was 2016-17.
So nobody appears, so list after 4 weeks. None appears for the petitioner on call. Mr. S. Datta, Surajit Datta. There are so many S. Datta.
Yes.
Surajit Datta, learned senior counsel, assisted by MS, is present for respondent number
2 and 3.
2 and 3 is present. And anybody else? Then in that case, so and so are present. List after 4 weeks.
Item 40, Lordship, we are petitioner. Lordship.
Huh?
Item 40, we are petitioner.
45?
40.
Yes. What do you want?
This petitioner is Lordship.
Huh? 4 weeks. Then in that case,
Short date maybe.
4 weeks. In that case, so and so, on the prayer of Mr. So and so, learned counsel for the petitioner. And the prayer not being objected to by learned counsel for the respondents, list the matter after 4 weeks.
Short
Then
date.
you write all this senior counsel and then they are present. Huh? Yes, next.
Date may be fixed, Lordship.
4 weeks, we'll see.
Reply given again.
Yes.
Actually, this matter is about land acquisition. In fact, my plot of land is acquired in the year of 2012.
Yes.
And in the meantime, from 2012 to 2025, there is a lot of development. The matter was placed before the Lok Adalat. I made several representations, joint verification was done. And finally, when I approached this honorable court, the executive engineer of the Water Resource Department has informed me and as well as the circle officer that land was taken in the year of 2012 as because the work was in emergent nature. So at that time, land was not acquired officially. So accordingly, the circle, the executive engineer of Water Resource Department requested the circle officer to initiate the land acquisition process. But this communication is page number 57 of my petition. I have the permission to read the very small portion also. The subject is the acquisition of land for already constructed embankment at Kochutoli area under Revenue Circle.
Page 57.
Page 57.
Of what? Reply.
Yes, reply.
Of your reply.
Of my reply, Lordship. 21st of October 2024. This affidavit was done.
No, this is page 57.
Yes, Lordship, 57.
Affidavit filed by the respondent number 7.
No, probably there is something in the pagination is wrong, but it is my petition.
This order dated 03/02/2024.
03/02/2024.
Yes,
Yes.
Yes.
This one.
circle officer.
Circle officer.
Yes,
It's addressed to the circle officer. That subject acquisition of land for already constructed embankment at Kachutoli area under Sunapur Revenue Circle. Reference is given the case number, which is my read petition. Sir, with reference to the subject cited above, I would like to inform you that an embankment was constructed from Kochutoli to Tilabasti area under the scheme extension of F/E along.
what is this FE?
This is the name of the scheme, Lordship.
What is the name of the scheme?
That I don't know.
You must know.
No, it is there in the affidavit itself.
Yes, read it. The conference, it may be mentioned here that during the construction embankment, no land acquisition was done as the work was emergent in nature. Therefore, in order to provide a compensation, then order, I request you kindly to initiate land acquisition. Yes,
Then Lordship, and it is the communication issued by the executive engineer, Water Resource Department.
yes.
Surprisingly, the chief engineer of the Water Resource Department, he has filed the affidavit, and which is the page number 46, Lordship. Yes. The page number 45, running page number 45 is the affidavit in opposition filed by the Assistant Chief Engineer, Water Resource Department.
Page,
Running page number 45.
it's not tally with the record, your page number.
Lordship, the affidavit in opposition which is filed by the chief engineer, assistant chief engineer of the Water Resource Department.
All affidavit in reply. Fifty-one. Respondent number?
It is respondent number 7, the chief engineer, Water Resource Department. Lordship, in his affidavit, in the paragraph number 6,
Affidavit in opposition, 22. Filed by respondent number 2 and 3.
2 and 3 are the deputy commissioner, Lordship.
Then
Then respondent number 7 is it is filed by some K. Samsul Alam, who is the assistant chief engineer of Water Resource Department.
affidavit in reply, affidavit in opposition filed by 54. Yes. This
Paragraph number 6.
yes. Next is the compensation for acquisition not paid to as no land was acquired by the authority during construction and embankment, hence the petitioner's claim for compensation. Yes.
We find that the executive engineer is telling that yes, land was acquired in the year of 2012, but could not pay the compensation as because the work was in emergent nature. And the assistant chief engineer is telling that compensation was not paid because no land was acquired officially.
It says something else. Something different. The compensation for acquisition not paid to the petitioner as no land was acquired by the authority during the construction embankment in 2012.
Yes,
No acquisition.
no, without acquiring the land, that my crux of the case is that without acquiring the land,
Hmm.
they have constructed the embankment. The land where the embankment is constructed, it is my land, it is confirmed by the deputy commissioner. But without officially, the land has not been acquired officially as following the due process of law. So illegally, they have occupied the land and constructed the embankment.
Where is any documents to show that this
Yes, Lord.
land belongs to you?
Yes, yes, yes. It is deputy commissioner himself confirmed.
No, forget Deputy Governor. You established, you show you from your own document.
Yes, Jamabandi copy is there, joint verification.
Where
report
it is.
Page number 14, copy of the Jamabandi
Hmm.
of my petition.
Brother, Nagan Biswas, Jiten Biswas, huh?
Yes, yes. And myself, I am the Jiten Biswas.
Kachutolipur. How do you know that the embankment was constructed over this land? You connect the land.
Yes, that is the page number 55,
Hmm.
joint verification report.
55 is something else. Where it is? Affidavit.
Yes, yes. It is my affidavit.
Huh? Submission of detailed report.
Regarding submission of detailed report in respect of Jiten Biswas.
Hmm.
Inviting reference to the subject cited above, I have the honor to
Joint-
submit here with
Yes,
a joint verification report on the Kheraji Miadi land covered by DAG number 739
Kheraz
and
Miadi.
Patta number 83 at village number 1 Kachutali Patar under Sunapur Moja, which was carried out with the official representatives of Water Resource Department, Guwahati official of the Land Acquisition Branch, Kamrup Metro District, Guwahati, Patradar of Jiten Biswas and local government, local gov, Gaoboda on 25/7/2022. In the field verification, it is seen that in a portion of the land measuring 1 biga 14 lecha covered by the said schedule of the land, an embankment was constructed by the irrigation department.
Yes.
This is the irrigation department. Sorry, Lord, water resource. Water resource.
Constructed by the Water Resource Department, they have confirmed.
Embankment is in your, for your safety. Why you
If
need?
your lordships comes to our affidavit filed by the respondent number 2 and 3,
Hmm.
page number 40. This is the letter issued to the circle officer by the executive engineer, Water Resource Division, wherefore it transpires that during execution of the work, the peoples of the landowners voluntarily allowed to construct the embankment to mitigate the flood damages to the vast area, to cultivate and homestead land of several villages and to save from annual flood inundation. That was the report submitted to the circle officer.
But your circle officer has written a letter for acquisition of the land.
They have now they have written a letter to the circle officer for acquisition of that land, but lordship, regarding that, I have no any instructions. I have, most probably I have to, what they are doing.
Lordship, in fact, Lordship, the land has been acquired by the embankment has been built by the Water Resource Department. Lordship, irrigation department has been wrongly implicated as a party here.
Water resource.
Water resource.
This is also
Water resource
confirmed
is
by
the-
Without acquisition of that land, as because their stand is that it was gifted by the.
Not gifted, voluntarily allowed.
Voluntarily allowed, yes,
And
lordship.
gifted
I'm
is-
sorry, lordship.
You
just
have.
gifted were-
You have voluntarily allowed.
Because, yes, meaning thereby I did not stop forcefully. I have allowed the construction because assurance was given to me that the compensation shall be given.
What a fantastic interpretation of the meaning of voluntary,
Voluntarily allowed.
huh? Voluntarily gifted.
Difference between
So the Water Resource Department is not a party.
water resource
Yes,
department
we are
is
the
a party, but the council is not available.
They have filed the affidavit also, chief engineer.
Up once you have given it voluntarily for
No.
construction of, you
No.
said so.
It is, Lordship, one thing is to be understood that I have voluntarily allowed the construction. One thing.
Yes.
That is, I have not donated the land voluntarily.
Hmm.
So without authority of law, the landowner cannot.
It was constructed way back in 2012.
Since then I am fighting.
Without there
Huh?
being any acquisition.
Since then I am fighting.
Where it is?
They have give up the.
Where it is?
Matter was placed in the Lok Adalat.
Huh.
Then Lordship, on the Lok Adalat, no decision was taken. Then I'm coming. And the Jirat, most interestingly, the list of the Jirat for providing compensation, the list of the Jirat also prepared and it was submitted to the.
Which year? Before or after?
After
Construction.
After construction.
And regarding that, in our affidavit, we have.
You have allowed to construct
I have allowed to construct
voluntarily.
voluntarily. Yes, that is admitted. But I have not donated the land voluntarily.
Heard Mr. So-and-so, learned counsel for the
Lordship, one
petitioner.
thing is that, let me complete my
And
submission.
also heard so-and-so, all of them. Since,
2, 3 and 4 lots.
since Mr. So-and-so,
I'm for 5.
no,
Oh, RM Das Lord,
learned counsel
water resource department.
is not present on behalf of, no. The respondent number, the main respondent particularly, namely the Water Resource Department is not represented by the council. List this matter after 3 weeks.
My humble.
It is too long. If it is short, it will be dismissed. I have heard you. I'm just giving you a space for some time. They are not entitled.
Not so good.
Dismissed on what ground? Lordship? Land is.
You are not entitled for compensation. List after 2 weeks.
Lordship.
You come up with better particulars.
42, 43.
Yes.
Matters pertaining to immediate amount.
Hmm.
My lord, here, my lord, the respondent, they have filed 2 affidavit
Admitting
admitting
or
the amount,
denying.
admitting the amount. My lord.
Yes. So
My lord, matter can be disposed of, my lord. My lord, kindly come to annexure 1. That is at page 20.
Hmm.
That is the administrative approval of the tender, my lord. And
Rajendranath Brahma.
yes, my lord, to the additional director, administrative approval by the.
It's okay. Where is your order?
Yes,
Work
my lord,
order.
work order is at page.
Quotation. Pursuant to the quotation.
Yes, my lord.
Yes. Then where is the work order?
Work order is at page
Tender compensation.
26, annexure 6.
What is the amount? Company statement supply of
Yes, my lord.
LED bulb.
LED bulb, my lord. And
Page 24.
page 26, my lord. Annexure 6.
is the supply order.
Sky Enterprise.
Sky
Student
Enterprise, my lord.
Yes,
Paragraph
I am
second,
directed
therefore you
for
are
the Central
directed to
Purchase
supply.
Board, BTC has approved your quoted rate for procurement 15. What is the amount?
My lord, amount is at page
127,
38, my lord.
total amount.
Total amount 11 crore 37 lakhs 42,000.
These are all work orders.
Yes, ma'am.
But this work order doesn't show page 26. It's only 1,27,800.
Yes, this is the number of pieces of the LED bulb, my lord.
Acha.
And
Total
the,
number of, okay.
yes.
It doesn't show the
Kindly
amount.
come to page 38, my lord. And it shows 16.
Okay.
This is the letter from the additional director, BTC, to the
Yes, sir.
Secretary Tribal Affairs.
Which numbers are please received from Hirambaran Nursery, proprietor MS Nursery.
Yes, madam. Kindly come to the third paragraph. In this regard, demand for sanction of fund in favor of Messrs. So-and-so amounting to 8 crore 62 lakhs only was submitted to your kind end, while letter number so-and-so dated 8 June 2022 and demand for rupees 11 crore 37 lakhs and odd only in favor of Messrs. Sky Enterprise was submitted by letter number so-and-so dated 8 June 2022 respectively, but fund has not been sanctioned till date. Now, my lord, kindly come to the additional affidavit filed by the respondent.
Page. Affidavit in opposition for and on behalf respond 2 to 6. For
My
what?
lord, there are two affidavit filed, my lord. Kindly pick up the first one. On 18/12/2024.
Yes.
Here, my lord. Here, my lord, kindly come to the inquiry report. During pendency of the case, my lord, they make some internal inquiry. And this is the inquiry report start at page 44 of this affidavit.
What does it say?
On the conclusion part, which starts at page 49.
Procedures were therefore carried according to the consent.
Therefore, the second paragraph at page 49.
Therefore, it is found that
Therefore,
the procedures followed for said supply of this and so. The tender of the supply was advertised in 6 April in the True Delhi newspaper.
My second paragraph
Is
of the
reported to be
conclusion, my lord.
existed. Therefore, if the not perhaps accommodate the required fund amounting to
The page 50, the upper part, my lord. Five zero. And for the said supply for the financial year 2019-20 is reported to be exhausted. Therefore, if the authority pleases, we might perhaps accommodate the required fund amounting to rupees 20 crore, either from the absent balance fund of financial year 2023-24 by necessary reappropriation or from SOPD fund of WPT BC. And now tribal affairs for the financial year 24-25 and sanction release the same
yes
to the concerned property.
Admitted amount, my lord, as per inquiry report.
So
Payment will be made as per.
huh?
If fund is available.
No, that cannot be. You just give us a time.
Following the existing rule.
Hmm?
Subject to available funds.
That cannot be. Supreme Court has clearly said non-availability of fund cannot be a ground to deny the admitted amount. Give us the time. 6 months.
No, my lord.
It's a huge amount. 6 months.
amount, my lord.
6 months.
My lord, similar matter, my lord, your lordship. has-
Heard, Mr.
By giving 2 months, my lord.
Just show us. Heard, Mr.
G. Bosu, my lord.
C.G. Boshi,
My
learned
lord.
counsel for the petitioner. This, both the writ petitions are,
Same, my lord.
work order is different.
Work order is different.
Huh?
In same inquiry report, work order is different.
Hmm.
Only the work order. The total amount is 20 crore.
Hmm.
11 crore is with Sky Enterprise. In the other case, 8 crores and odd. Total 20 crore.
One by one, huh? It would be almost the same thing. They have called the person. I heard S.G. Bashir and counsel for the petitioner and
R.K. Musari.
R.K. Moshari, learned standing counsel, BTC.
British.
One, and they on behalf of Aadhar,
Huh?
and they on behalf of Aadhar, respondent number 1.
Who is respondent number 1?
State of Assam.
Hmm?
Tribal affairs. Like.
Aggrieved by the non-payment of outstanding amount of rupees 11 crore 37 lakhs 42,000, comma. The petitioner has filed this writ petition seeking a direction to no. Before the 11 crore 37 lakhs 42,000 for supply of (15 watt) Cisca/Philips LED bulb for distribution to SC/ST/OBC and BPL beneficiaries in the BTC area. Comma, the petitioner has filed this writ petition for a direction for payment of the said amount. Please stop. The petitioner was no, the petitioner is a registered firm dealing with the government contract and general order supplier. Please stop. Pursuant to the NIT or quotation. Is it quotation or NIT? Pursuant to the quotation dated
Quotation dated
05/09/2019,
29.
issued by whom?
Issued by the additional director
CHD, WPT, BC, BTC.
Where it is?
At the bottom, my lord, at page 21.
Issued by the additional in charge additional director, CHD, WPT and BC department, BTC, Cochrane. The petitioner form was awarded the work of supply of LED bulb. It's all LED bulbs only.
LED bulb. Two different places.
LED bulb within bracket, Cisco oblique Philips 15 watt, bracket close. For distribution to the SC oblique SC, SC oblique ST oblique OBC families for an amount of rupees 11.
Yes, my lord. 11, comma 37, comma 42.
Work order is this of amount. No amount has been paid, even the part payment.
No.
Okay. For an amount of rupees so and so, Accordingly, the petitioner has supplied the LED bulbs which has been duly acknowledged by the respondent authorities. List of the petitioner. Please, sir. However, despite repeated approaches, the respondent authorities has failed to pay the said amount. Mr. G. Bashir, learned counsel for the petitioner, submits that the amount claimed by the petitioner is an admitted amount, as the same is in respect of the supply order issued by the respondent authorities, which the petitioner has already executed and the acknowledged and has been duly acknowledged by the petitioner, the non-payment of the claim amount, outstanding amount of rupees, amount of the petitioner as deprived the petitioner by depriving petitioner has deprived the petitioner. Therefore, he submits that the respondent authorities may be directed to release the outstanding amount of rupees 11 crore 37 lakhs 42,000. Mr. When did you supply the work order?
22 itself.
Items?
22.
Which 22?
My lord, it reflects in
Tera?
in additional affidavit also.
Next para. Mr. So-and-so learned standing counsel BTC fairly submits that there is no dispute regarding the supply of the LED bulb by the petitioner and the amount claimed by the petitioner, and the, for which and the amount claimed by the petitioner. However, due to paucity of fund, payment could not be released by the respondent authorities. He submits that as and when the fund is available, same shall be released to the petitioner. Next paragraph. Having consider the submissions and learned counsel for the parties, and considering that the amount claimed by the petitioner is an admitted amount for supply of LED bulbs pursuant to the quotation dated 05/09/2019, and the supply of the said LED bulbs has not been has been duly acknowledged, comma. I'm of the considered view that I'm of the view that writ petition can be. No, I'm of the view that the petitioner is entitled to be entitled to the payment of the aforesaid amount claimed by the petitioner, as there is no reason as to why the petitioner, as to why the payment should be denied to the petitioner. Please stop. Please stop. In view of the above, it would be appropriate to dispose of this writ petition with the direction to the respondent authorities, particularly
CSTWB.
respondent authorities in the BTC, in the BTC, to will not say verify,
Already.
but then they have said it needs to be verified again.
No, it is already verified.
But they have said in the affidavit.
No, kindly, there is the second,
Anyway.
second affidavit, my lord.
What is it? That's to pay the amount claimed by the petitioner. Pay the. You just read the. I mean. The direction to pay the amount claimed by the petitioner. Please do accordingly. It is directed that the respondent authorities in the respondent authorities
My lord,
respondent authorities in the BTC
may I intervene, my lord? Kindly, there is
Shall-
132 page, paragraph 4.
it's okay.
Yes.
Shall properly shall verify the claim of the petitioner. Come on. And if found admitted, shall be paid to the petitioner within a period of 6 months
My lord,
from the date of
within
receipt
2
of
months,
the.
my lord. All other, or 3 months, my lord. All other,
4 months, 4 months, 4 months from the date of receipt of the copy of this order. Same quotation, next case,
yes, my lord.
name will be different and the amount is,
Amount is different, my lord.
you just tell the amount.
Yes,
Check it from there. But out of same quotation,
yes, my lord.
right? And supply of LED only,
And
LED bulb.
yes, my lord. And the admitted amount is also the same. Kindly,
Tell us the amounts, sir.
my lord, 8 crore 62 lakhs 55,240.
You verify from the, huh?
44.
Name will be different. For everything, name and amount will be different. Rest will be same.
Deeply of
Yes, we'll finish this before.
Please, Lordship.
Yes,
Yes, on a writ petition on award dated 16 December 2022 on insurance ombudsman.
huh?
Insurance Ombudsman Order dated 6/12/2022.
Yes. So,
My learned friend has filed affidavit in opposition, but we need some instructions from our client, but we cannot communicate with our client.
so
So we need
what's wrong? What's the difficulty?
certain policy relating some query. So we need some instruction. from
What
our-
is the matter? Bharti AXA Life Insurance Company Limited, huh?
May I submit, my lord? My lord, deceased my lord died. He had a policy, my lord. Before his death, a policy, insurance policy was initiated, my lord. That
Hmm.
policy was granted, my lord. And you lordship kindly see page 123. That is the, my lord, the order passed by the insurance ombudsman, my lord.
Hmm.
Relevant portion, you lordship kindly see page 123. Observation and recommendation. Your lordship will understand everything, my lord. Observation and recommendation.
Page
Page 123 of my affidavit now for you.
123. Yes.
May I read, my lord? Very simple matter, my lord.
Yes.
During the course of hearing, the complainant stated that the insured, that insured already died, my lord. Insured, her husband had taken elite advantage policy of the respondent insurer commencing on so and so with some assured amount of rupees so and so. The insured expired on so and so due to cardiac arrest as mentioned in the hospital death certificate. The complainant stated that the deceased insured was 62 years of old and his medical examination was conducted by the RI prior to coverage. The RI means, my lord, prior to his initiation of his policy, deceased was, my lord, checked up by their doctor, my lord, insurance doctor, my lord. No disease was found.
So what is the RI?
RI means prior to coverage with all
Was conducted by the RI. What is RI?
RI, my lord,
Were found to be normal.
meeting,
She further confirmed that the disease insured not having any.
and now, my
They
lord,
are in the receipt of repudiation letter that is from the RI on grounds of non-disclosure of fee. She denied the same and appeared for payment. Respondent then,
my lord, after the date, my lord, my lord,
of course, there is evidence of such PED which warrants any disclosure on the part of the insured. Hence, the repudiation of the claim relying upon these documents only does not appear to be in order. The claim merits settlement. Huh?
already, my lord, some
Respondent insurer is directed to settle the claim by payment of death benefit
debt
of
payment, my lord, debt benefit.
21 lakhs.
No, my lord, 2,14,462.
Huh.
This is the, my lord, debt benefit, my lord. And they denied on the ground, my lord, prior to his, my lord, policy, he was suffering from illness from diabetics, my lord. My lord, as per policy condition, my lord, diabetes, they, my lord, examined, my lord. Deceased was examined
Yes,
by
what
the
do you want?
doctor. By the doctor, no.
Suppress the fact, because earlier they have denied they have no diabetes, and later they have shown the diabetes patient.
That ombudsman has not accepted that at that point of time when it was insured, he was not having a disease. That reports cannot be accepted.
My lord, they, my lord, examined the disease, my lord. They examined, the examination report is here, my lord. My lord, diabetes, my lord.
We're fixing after 2 weeks.
Okay.
Inform the petitioner to pay by next date.
Okay, we communicate. My lord, they think
Heard Mr. So-and-so, learned counsel for the petitioner, and Mr.
that-
A. Mannam, learned counsel for the respondent number 1. Who is for ombudsman? Nobody. Ombudsman, nobody. Please stop. On the prayer of Mr.
Say Taluka.
Learned counsel for the petitioner, list this matter after 2 weeks. List of uh, for instruction, to obtain instruction. List of on the next date, Mr. So-and-so learned counsel. By the next date, considering the issue is having considered the issue raised in this petition, the petitioner is expected to honor the decision of the ombudsman. By next date, tell him to pay. Nothing is there.
There actually, my lord.
You had some examination after he was insured.
Yes, my
Pay it by next date.
my lord, only,
Tell him.
on the ground, my lord, may I explain, my lord?
That's all. Thank you. We'll see next date.
Of like,
45.
a date may be fixed, my lord. Otherwise, my lord, it will.
Give the date. Yes, 45.
May please, your lordship.
Yes.
Respondents were directed to file affidavit, your lordship, on this matter.
So no affidavit.
Lordship, affidavit can go with additional instruction. So, Lordship, we have been directed to place the copy of the Khatian. And we have received that copy of the Khatian, but it is written in vernacular, Lordship. So, may I pray for
Khatian. To place before the certificate copy of the above mentioned Khatian. Heard Mr. So-and-so learned counsel for the petition. Mr.
H. Sharma?
H. Sharma, learned counsel, learned state counsel.
Lordship.
Submits that he has received the Khatian, a copy of the certificate copy of the Khatian, being number 247 as directed by this court on 25/11/2024. However, same is in vernacular. Therefore, please therefore praise this. Sometime may be granted for translation. Translation.
Translation, Lordship, may I pray for 2 weeks' time? Lordship, translation is also very much difficult. It is written like this, Lordship, this Khatian.
To have a proper translation of the said Khatian. According to 2 weeks' time is granted. Anybody in view of above, let this matter be listed after 2 weeks.
In this case, in last occasion, my lord, one Mr. Narjani appeared and he paid for my lord that two pathogens appearing in the behalf of respondent number 6, my lord. So in that respect, my lord, another my lord, I was filed for imprisonment, but the I was not been listed my lord, as number. So we have ready to file the my lord, objection, but because of non-availability of the number, that could not be filed, my lord.
For what? Implement.
Implement that is filed by the another set of my lord advocates. It is filed by my lord. Some Padmeswar Deka, my lord. He is the advocate, my lord. But his name is not shown today because IA is not listed. Probably that reason.
It is submitted by Mr. P. Mahanta, learned counsel for the petitioner, that he has received a copy of the IA. Filed by whom?
Padmeswar Deka, my lord, for implement of the respondent.
Filed by one Rajeshwar Deka. Padmeswar Deka for implement. Mr. However, the same is not listed. It is not listed along with this, along with the writ petition, for which he could not file the objection. Mr. Considering above, let this matter be listed of the three weeks.
Well, the last occasion, another order was to list along with the 992 of 2024.
List the matter
But
up to
because
3
of the
weeks.
certain mistake, that was written as a 21. So
Mr.
wrong record has come.
B. Gogoi, learned standing counsel.
Health
Health Department is present. List the matter along with WPC 99. 2020, 2009
992.
2 of 2024.
24. Sir, I'm wrongly. Mass submission.
In this case, Lordship,
My affidavit has already been forwarded for vetting losses.
Okay. And Mr. Swenson, Mr. P. Nayak, Learned Counsel, Learned Standing Counsel, PWD.
Yes.
Press for is granted for the 3 weeks time to file affidavit.
Alright.
Well, in this case, well, the petitioner has been inherited lordship, he because he cut a 13 lesses land from his father lordship.
So
Batta land lordship under 73, that number 73 lordship.
anybody
Now-
appears for respond number 5?
No knowledge, appeared lordship, the respondent member of the state council has accepted lordship. Now, what I am submitting lordship, the circle officer, my lord, respondent number 5 has stated in affidavit that there is no that number by the name and number, my lord, 73 lordship.
Yes.
My lord, on the other hand, this my lord, revenue Sirasta there of deputy commissioner lordship, my lord, issued my lord the copy lordship. That is kindly see the additional affidavit and reply lordship. Page 52.
Lordship, I am praying for some time, Lordship, that's because we have not yet received any instructions from the Sirastadar, Lordship. He has been newly impleted as respondent number 5. Lordship.
Okay.
So
And
with-
Mr.
with
Swenson,
relevant
Learned
record-
Counsel for the parties,
My lord,
petitioner, Mr.
H. Sean.
H. Sharma, Learned State Council appearing on basis respondent number 5. And then Learned State Council submits that he may be granted some time to obtain instruction from the newly implemented respondent number 5.
Revenue Sirastadar.
Mr. President, list the matter after 4 weeks.
Lordship,
On the next day, Mr. S. Sharma,
I will try my
H.
level.
Sharma, Learned Counsel, to place the instruction.
my lord, record may also be directed to be placed lordship because my lord,
Let us,
this is
let us
very,
first
this is
what
very
is the-
relevant in
okay.
this case lordship.
Yes, we'll
Confirm
see.
with
We'll see.
lordship.
49.
All right.
Lordship.
Yes.
This instant petition, filed for protection of property, my lord. That
Huh?
property, my lord. The petitioner filed on representation page, annexure 11, page 41 to 42, my lord. Only one direction may be given to restore the property, as because, my lord, the father of the petitioner martyred, was in the, died in the, martyred in the year 1983, my lord. Thereafter by legal,
What is
they are,
this?
my lord, following.
He has no case, your lordship. Earlier also he approached in the same facts and circumstances in the same prayer, your lordship. This is the direction, your lordship. Disputed fact, no case, your lordship.
Kiran Balla Laskar.
Yes.
Now now this is by Beauty Laskar.
Yes, and another.
Kiran Balla.
Yes. And Kiran Balla has power of attorney, on the basis of power of attorney, Beauty Laskar has come now,
Ah.
saying, daughter and mother.
Withdraw.
Daughter
What
and
is,
mother.
what is this?
Actually,
Earlier
Will
mother
impose a cost
my junior.
on the lawyer, not to the petitioner. Withdraw. Otherwise, we'll pass
My lord,
stricture
my lord.
against the lawyer, not the petitioner,
I'll let debating.
not liberty. Heard Mr. B. Islam, Learned Counsel for the petitioner, who prays that he may be allowed to withdraw this writ petition, having realized that the writ petition has been instituted by suppressing the earlier proceedings, which has already been dismissed.
Debating observation was given.
As by obtaining the power of attorney from the earlier petition. Please stop. Although this court expresses its deprecates the conduct of the petitioner, comma, says the petitioner, no, comma, the writ petition is allowed to be withdrawn with a condition that the petitioner as well as the learned counsel shall be cautious in future. List of writ petition instance dismiss on withdrawal. I'm taking a lenient view. This cannot be permitted.
My lord.
You cannot do like this.
Done the wrong, my lord. That should be mentioned.
You should not have,
My lord.
I mean, allowed him to say anything. Be careful,
Apply.
Mr. Islam.
Apply.
Yes, next. Yeah. Huh? No.
Item 50.
Yes, government, any instruction? Non appears for the petitioner on call. You are supposed to obtain instruction.
Yes, Lordship.
MS so and so learned counsel for the learned state council
Council, Lordship.
is granted further 3 weeks time to obtain to complete her instruction. This after 3 weeks, make it 4 weeks. Huh? Okay, we'll get up, we'll continue it to continue it.
May I pray for a minute?
Disposing of appeal under section 9. You know, that there is a difficulty, in fact, that we have challenged an order dated 30th of January of 2018. Now, in fact, there was no order annexed in the application, or also there is no, perhaps there was no order on 30th January passed by the railway authorities, the state office. Since there was a publication and public announcement that on such and such date an order was passed, thereafter the appellant has preferred an application under section 9. But thereafter, after this judgment has been passed on 10th January 2019, the final notice has been published under section 5. So one indulgence we are just placing before this honorable court, my lord, that in fact we have to prefer a section 9 application.
So withdraw and prepare, we'll give you a liberty.
With a liberty.
Heard Mr. B. Dutt. No, Mr. B. Dutt, learned senior counsel, assisted by
Yes, taken.
learned counsel for the petitioners. Petitioners
Yes.
submits that he may be allowed to, this writ petition may be closed. No, he may, withdraw.
Withdraw with the
With the liberty to
yes,
approach
the 18(1)
to avail the appropriate remedy.
under section 9 before the appropriate court.
Will not say anything, will give you liberty. Huh?
Now, unless this is indicated, my lord. then
Okay,
is a
submits
difficulty.
that he may be allowed to withdraw this writ petition with a liberty to avail the remedy under section 9 of
The public.
71. List of Mr.
Be sure.
B. Sharma, learned
Standing council.
standing counsel railway has no objection to such prayer for withdrawal and the objection to the prayer of withdrawal and to and a liberty to avail the remedy. Avail the remedy,
To challenge the
appropriate remedy.
yes, eviction notice dated 18/1/2019.
It's okay. In view of above, considering submissions of Learned Senior Council and then Standing Council review, the writ petition stands closed on withdrawal with a liberty to the petitioners to avail the remedy under section 9 of the public premises so and so against the
Eviction notice dated
eviction
18/1.
notice dated
18/1/2019.
2019. Automatically
Automatically.
merged.
52. Grateful.
Okay.
I have received an affidavit in opposition today itself.
Waiting for respondent number 5.
So some time may be given.
Mr.
FJ Majumdar.
FJ Majumdar, Learned Counsel for the petitioner, praise for and is granted for that, not further, granted 3 weeks time to file affidavit in opposition to the affidavit in opposition filed by the petitioner. Why? Why?
Because my senior instructed me.
Okay, MS so and so,
Yes.
MS A Hussain, Learned Counsel for respondent number 5, and who else are present? Record all of them.
Item 53.
Lordship Day, item number 53.
Huh?
Lordship Day, some more time may kindly be granted to us for giving instruction. Lordship.
What is the matter?
Matter relates to delimitation of Gaon Panchayat.
Okay, I think similar matter are listed before some other court.
Yes, on 17.
Okay, none appears for the petitioner on call. Mr. So and so, Learned Counsel for the petitioner so and so is present. Mr. B. K. Court,
K.
Learned
Kaur.
Additional Advocate General, Assam, praise for and is granted for the 3 weeks time to file affidavit.
Affidavit. My lord, a date may kindly be fixed, lordship, because otherwise the election will be held, lordship, in the month of. Because basic grievance is that, lordship, the electoral law was not prepared, lordship, as per law.
Hmm.
So, lordship, a date may kindly be fixed
After 3 weeks, give the date.
54 also similar prayer. You also.
Same order. Here also, who is appearing here? 54? None appears, huh? You are appearing?
54, lordship.
I didn't record the name, 54, huh? Then 55. After 3 weeks.
55. Well, in this case, respondent number 3 has already filed an affidavit. I have received a copy. I want only 1 week time to get instruction, my lord, from my client. Only 1 week time.
For withdrawal.
Maybe I'm.
What is the claim?
Claim actually, my lord, what happens in this case, in pursuance of a contract of making biopic under the Department of Cultural Affairs, petitioner has accomplished that program. And he is entitled to remuneration of rupees 25,20,000. Accordingly, that was sanctioned, but the authority has going to release the amount in favor of the respondent number 3.
Yes.
That is where we have before this honorable court. Some affidavit is there, my lord. Affidavit by the respondent number 3.
They are saying that it will be released.
If yet not released till date. My
It
lord.
will be released.
Released, my lord.
We'll close it.
My lord, only.
If it is not released, you come back.
No, my lord, only 1 week time I want get instruction from my client so that I can say that yes, I want to withdraw the petition or they will get the payment. Only 1 week time. That can be
Yes.
fixed.
No, I'm appealing for response number 3 here. In this case.
You are the one who has
Nothing,
to,
nothing.
who has to release.
No,
No.
you will get the payment.
Acha.
Only 1 week time, only 1 week.
We have provided him the loan facility.
Hmm?
We have provided him the loan facility.
Acha,
The
acha.
next week
Okay.
for the project.
Okay, on the prayer of Mr.
Yes, sir.
Yes, sir, learned counsel for the petitioner. List this matter after 1 week so as to enable him to obtain instruction.
Obliged.
56.
In this matter, my lord, on the earlier occasion, notice was issued, my lord.
Hmm.
Only, my lord, today they will have to, my lord.
56 losses, I have received instruction losses at least 2 weeks.
2 weeks, 3 weeks, 4 weeks.
2 weeks, 2 weeks.
Heard Mr. So and so, learned counsel for the petitioner. Okay. Mr. K, learned counsel. State council, learned state council, praise for and is granted 2 weeks time to file affidavit. List after 2 weeks.
Interim be extended.
Interim order passed and they shall continue.
Highly obliged.
57.
Matter relating limitation on Panchayat. Similar matter of 17 ma'am.
Affidavit has been filed.
No, your lordship.
It also filed on 17 ma'am.
17 is not possible if
Yes.
the affidavit is not Mr. So and so, then counsel, Mr. K. Court, Learners, Magician Advocate General, from Assam, press for 3 weeks time.
2 weeks, my lord. The date may be fixed, ma'am.
Other matters are after 3 weeks only.
Date may be.
Obliged.
3 weeks, 3 weeks. Give the date. We have given the date.
58.
Hmm. 17 April. 17 April.
May I please, your lordship?
Yes.
Lordship, the matter relates to acquisition of the land, and on the last occasion, notice was issued.
Hmm.
And this matter relates to the grievance by the petitioner, which goes as the respondent, they have installed a plant under the Jal Jeevan Mission scheme in the part of
don't
the
want-
plot of the land.
You don't need water?
No, lordship, they have not taken any permission from us.
No, you don't want, need
So-
water.
They should have given,
This is for supply of water, drinking water.
but they have not taken any permission, lordship.
Are you the beneficiary of this scheme? Are you a beneficiary of this scheme? You are not,
They have.
you
not
don't
taken
want,
any-
you don't want drinking water.
We want, but they have not taken any permission, lordship.
What
and
permission is, the government is providing with water? What is most important and most important part of the life?
They should pay us some compensation.
How much you want? How much you want?
The actual amount which is right now.
Plant is been installed, plant has been installed
But they
for
should
your benefit only.
Take our permission, lordship.
We'll ask them to take permission, only permission.
And compensation also.
Lordship, in JJM, the land we don't acquire. Either the person donates us the land or gives us the land, Lordship.
So
voluntarily.
there is a dispute.
Now they are saying they have not donated the land.
Yes, lordship. Instead, we have filed.
No, I am asking, don't you want drinking water? You don't need water. You don't want that the water should be supplied by the government under the scheme.
But the government should also inform us about this.
You file affidavit, have you filed affidavit? You file affidavit. MS so and so, learned counsel for the petitioner. Mr. R. Gogoi. Learned counsel. Learned standing counsel, PHE.
PHA, Lordship.
Praise for granted 3 weeks time to file affidavit.
Date may be given.
Then in that case, we'll direct not to provide water to you. We'll see after 3 weeks.
Supplementary course list, admission item 76.
We'll see. We'll see.
The
Yes.
place of the petitioner is located under the, within the district of Hujai, my lord. They
Yes.
have been paying their revenue, land revenue to the Hujai administration.
Mm.
And the village is located along with the border of the Karbi Anglong district autonomous council.
Mm.
In 2019, my lord, the administration of the Karbi Anglong Autonomous Council enclosed the petitioner's village and destroyed the. But at the instance of the administration of Hujai district, they were safe. And thereafter, they approached this court, honorable court, and this honorable court stayed the eviction. My lord, thereafter, my lord, in the year 2023, the government suggested that they publish a scheme for allotment of patta to the landless person. And they withdraw with liberty. And subsequent to that, my lord, they again evicted some of the petitioners' houses, my lord. And this honorable court also was interim granted, my lord. In this case,
So enjoy the interim order heard Mr. A.K. Datta, Learned Counsel for the petitioner. You have filed the affidavit. Pleadings are complete. List after 4 weeks.
my lord, it is here that the survey team surveyed the area, my lord, boundary line. And
So we'll consider on next date.
my lord, they have not filed any affidavit.
They filed.
Only says, only my lord,
Who has to file the affidavit?
5, 7, and 6.
Are you not representing? Yes. Already filed. Serve the copy. Huh? No. Learned Counsel for the Learned 6 and the Learned Counsel for KACC to furnish the copy of the affidavit file. Yes.
My lord, Karbi Anglong, I have received, my lord.
So who has to
From
file? Who has not filed?
My lord, 1 and 2, my lord.
Who is
Government,
1 and 2?
Secretary to the government of Assam, my lord. They have submitted the survey report to the government.
Huh?
Survey report to the government.
Okay, in that case, affidavit, you cut that, huh? Heard so and so, okay, that LMS so and so. And the, no, heard so and so, okay, that Learned Counsel for MS so and so, Learned Counsel for KAC has submitted that she has filed the affidavit on behalf of the respondent 6 to 8.
6 and 8.
6 and 8. Mr. A. Bhattacharya, Learned Counsel for the Learned District Council is granted further 3 weeks time to file affidavit on behalf of respondent 1 and 2.
I need 3.
1, 2, and 3.
No, I pay for 2 and 3.
2 and 3.
2 and 3.
Who is for 1? Record their name and then Miss MS so and so, Learned District Council for respondent number 1 and Bhattacharya for respondent 2 and 3. I granted further 3 weeks time to file affidavit.
77.
Obliged.
Why this has been listed unnecessary?
We have further respondent 1 and 2, madam. But
Yes.
3 weeks time to file my affidavit.
My lord, I think they cannot improve anyway by filing an affidavit.
Let me get the entire inspection.
They have not complied with an order of their own appellate authority. Lordship will see.
Anyway, sir, he has the right to respond to your
No, they didn't
claim.
exercise that right in time.
Well,
That is why my submission is they have failed to exercise that right. They cannot, on the pretext of that right, drag in. The issue is very simple here. This honorable court directed that you dispose of that representation looking into his grievances raised there. The authority, instead of looking into those grievances, they turned around and said something else which is not relevant to me. I went in appeal before the mayor and council in the municipal corporation. They said that, well, you have overlooked the core issue. So better it should be remanded back to reconsider it. 1 year gone. They are sitting tight. They have not done it. My grievance-
Consider.
Well, Lord,
This is the only thing.
After 3 weeks, my lord, in the meantime, I will.
No, it's only remanding back to consider. They have not taken the decision. You have not been directed to take a particular
Exactly.
decision which may prejudice to you. What is there?
They have to just
Then
relook it.
Lordship will direct the commissioner to consider the taking account of the appellate authority order. Lordship will find
And the direction of this honorable court. That's all.
Page number 99.
Within time frame, let them do it within time frame.
Page
How
99.
can they sit on this so long?
I'm for the private attorney.
Yes.
I'm for the private. attorney.
So, huh?
Have to make some changes. Here, what happened?
You will have his right to represent there.
We'll take after a week. Let them, we'll dispose of after a week.
Yes, yes.
Lordship will proceed after 2 weeks, Lordship.
1 week.
No, Lord. Let it.
You take obtain instruction and then apprise the authority, the tentative view of the court that will direct it. You have to act on it
Yes.
because matter has been remanded and there's a order of this court. That's all.
Lordship.
That's all, my lord. Here is,
And
they cannot
Mr.
raise anything.
K.K. Mahanta, learned senior counsel, assisted by so and so learned counsel,
For private attorney, 7 to 10.
and Mr. So and so for response number 7 to 10 and all this. Mr. S. Bora, learned standing counsel,
For 1 and 2, my lord.
GMC,
GMC, Lord.
to obtain instruction. List after a week.
Lordship may fix a date, my lord.
Just after a week, it will be
After a week.
listed.
Let it be on 21st, my lord.
It is
Everyone
21
might.
Hey, demand him. Demand, I hope not.
In fact, direction is also not required.
Well, Lordship will post it in the 21st. I will come with all the instructions.
You are obligated.
They cannot escape that obligation. It is already there. But they have not acted about sleeping over. As usual.
Hopefully, you decide it within
That
1
is-
week, so that the fresh cause of action may arise.
That will be intelligent course for them. Let us see how they do.
On 21st, my lord.
Lordship has indicated enough and enough. Let's see. All right.
78.
What is this?
May I submit your lordship?
Yes,
In this case, as per Lawadima order, 10/3/25, charges upon the legal error of, this is resolution number 9, is deemed to be served because notices were refused.
is there any order?
10/3/25.
10-3?
2025, your lordship. Most probably in the next file. There is somewhere, I have seen the order.
What is the matter?
My lord, here, the petitioners will not,
In IA.
there is no IA, my lord, IA is in it.
For substitution.
It is for substitution. In fact, in this case, my lord, the government has filed a counter. As per the last order passed by this honorable court. I want to file a short rejoinder, my lord. Lordship may take up after 2 weeks. my lord.
IA, in IA, you right? IAC 3633/2024.
Plainer road. Oh, my IA is for substitution. Substitution. For substitution. And that,
Regarding service of notice, it is complete, your lordship.
Office note dated, no,
Sub-
Lodging
substitution
Courts
is it?
order dated 10/03/2025.
oh. Oh. A notice on the IA was issued, I mean, served, it was, I think.
Indicates
It
that
was
the
refused.
notice upon respondent number 1.1. What is 1.1 and 1.2? 1.2
They are the legal heirs of respondent.
has
number
been received back and served with the postal remark refused RTC, comma, considering the Mr. in view of the observation, in view of the Honorable Supreme Court's order dated Honorable Supreme Court's no, in view of the judgment and order by the Honorable Supreme Court in the case of N. Paramaswaran Mundi versus G. Kannan. The service of notice upon the respondent numbers 1.1 and 1.2 is deemed to be served.
Lordship, and in the main case, they filed, they were.
In main
asked to-
case, heard Mr. P.K. Rochod, learned senior counsel assisted by so and so, and Mr. Edison, Edison Advocate General, and senior assisted by Miss M.S.
D. Devi.
On the prayer, Mr. P.K. Roy, P.K. P.K. Roy, learned senior counsel, missed this matter after 3 weeks, so as to enable him to file affidavit in reply. Yes. Record her name. Is present.
3633 is disposed of.
That's substitution.
Substitution.
Okay,
Because if notice is served, they are not.
36, what is this? 3633.
Yes.
Is disposed, self
What
disposed.
disposal? Complete allowed, so and so, hard so and so, huh? Implement allowed.
Please, sir.
Parbo,
No, 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 no.
all right.
But this
Hard-
IA stands disposed of.
We'll have to implement.
My lord.
Oh, yes,
Lord-
yes.
Lordship will have to dispose of this.
Substitute.
Yes,
Yes,
Lordship has to pass a formal order that they are substituted because
Ah.
notice is when
Yes.
no order was passed
Mhm.
allowing this petition.
Okay,
So
okay.
Lordship will have to pass it.
Yes,
Then in
yes.
that case. This is filed by the
Petitioner.
petitioner. Okay. In that case, you said, heard Mr. P.K. Rochod in IA, huh? You just delete that, huh? P.K. Learned Senior Counsel assisted by so and so, and Mr. D. Majumdar, Learned Senior Counsel, and Additional Advocate General Assam, assisted by so, same, huh? This is an application for application praying for
Petitioner.
substitution of the
Number
legal
9.
heirs of the, this is respond number 9.
1912 people.
Yeah.
Please do. Then you write, in terms of the order of Lajima Court, that is so and so, huh? The same, that thing you give that. Notice in respect of, huh? Service, notice in respect of respond number 1.1, 1.2, so and so, has been received back unserved with the postal remark refused, huh? List of, in view of the decision of Honorable Supreme Court, huh? In a Paramasivaran Undi versus so and so same, huh? The notices upon respondent number 1.1 and 1.2 is deemed to be served, huh? Next paragraph.
Phone number 9 would be substituted by.
Having considered the submissions and in view of the fact that the respondent number had expired during the pendency of this, during the pendency of the connected writ petition being connected WPC 4402 of 2024, the respondent's number
9.
1.1 and respondent number,
The main case minute is phone number 9.
is it?
Yes.
Okay. No, this is the respondent number 9
To be substituted.
be allowed to be substituted by the present respondent number 1 and 1.1 and 1.2
Their names
may be
Their names may be mentioned.
mentioned here.
as the
Priyanka Borua and Master Prithviraj Borua.
where it is.
My lord,
Page
it's page
620.
622 of the in this case. It is number.
Namely so and so,
Paragraph 2. Paragraph 2. Their names are in
be allowed
paragraph
to be
Correct.
impleted. So after impleted, do you need to send a notice again? Because the
I
notice
think-
was
yes.
for this
This
application.
IA.
IA.
Now fresh.
Please, sir.
Since they have refused to
Just,
allow to
it's
that.
all right. According to writ petition, the IA stands allowed and disposed of. And same in main writ petition, order will remain same. Then we'll issue a notice
Yes, and they will have to.
in view of the order passed in so and so, the the substituted respondents, namely so and so, so and so, number 9, newly substituted respondent number 9 be no, to be issued notice, list of in view accordingly the learned counsel for the petitioners to take steps for service of notice
And they
upon
will
the
file an application.
respondent number 9.
Corrected posted, they have to file. Lordship may mention that they will file. a
I'll
corrected
file it.
posted.
No, in that case,
Settle may be corrected.
in view of the order passed in the IS so and so, today, so and so, the petitioners to file amended cost title within 2 days. 2
Within
days.
a week, you know.
Within a week, list of. On incorporation of the substituted respondent number 9. Let notice be issued to. Let notice be issued. Please stop.
Duly period response.
Then petitioners to take steps.
And to file corrected.
No, that I have already.
Obliged.
79.
79.
May I please, Lord? In
Yes.
this case, my lord, the husband of the petitioner, my lord, died in an accident, my lord, in public place, my lord. As per the police report, my lord, at page 12, my lord, he died in the public place, my lord, following a beam, my lord, a concrete beam on his head, my lord, and died in the spot, my lord. And under the notification of 2015, my lord.
Yes,
Within a-
madam.
Communicated the honorable court's order with the department, Your Lordship. I'm still awaiting my instructions.
Hmm?
I'm awaiting my instructions, Your Lordship. I've communicated the order, Your Lordship.
My lord, may be verified and be and if the petition is entitled.
Heard Mr. So and so, learned counsel for MS in Bordeaux, learned standing counsel, revenue department. is granted further 3 weeks time to obtain instruction. Instruction. Okay,
Date may kindly be fixed, my lord.
we'll see after 3 weeks.
Then it goes the orders item 60.
Private service report, list after 3 weeks.
My lord, it was, my lord, many days has gone by. 61 also.
61.
Same order.
My lord, someone has.
Out of
My lord.
same order.
Same order may kindly be, yes, my lord.
Hmm?
After 2 weeks, my lord, it is also. My lord, may be taken after 2 weeks, my lord, in this case, my lord.
It's a similar
Similar
erased or
contempt petition, my lord.
erased or same order
No, my lord, same order,
Different.
similar order, my lord.
on the prayer of Mr. So-and-so, and council for the release the matter after 2 weeks.
My lord.
63.
Lordship, we would like to file an affidavit by showing non-compliance of the order.
Here I'm appealing for response number 1, my lord. Need some time to file our affidavit to clarify our stand, my lord.
This
Contempt number 1.
on MS so-and-so, learned council for the petitioner. MS
P.R. Mohanto.
PR Mahanta, learned council enters appearance on behalf of, you are appearing for the first time.
Yes, my lord. Response now 1.
List contender number 1, who phrase that she may be granted further. And phrase 2 weeks time to file affidavit.
My lord.
Phrase the list after 2 weeks.
64.
May I please, your lordship?
Yes,
If this is the condemned case, your lordship, I'm appearing for respondent number 1 and 2, your lordship. This is some instructions.
what's there?
They have,
Complaint.
yes, deposited the money.
The direction was to grant compensation ex gratia,
Yes, lordship.
right? This is of 7-1. We'll close it.
Yes,
Lordship.
lordship. Revenue department also has.
He is entitled for 2 lakhs.
But as per my instruction, they have not get amount. Yes, on that, your lordship.
What is this?
The, your lordship, DDO, they have deposited the.
The additional deputy commissioner in charge, Nazir was Nagaon. He's requested to, you go there and collect it if you have not received it. It is a direction to disperse. Heard Mr. So-and-so
Lordship,
learned counsel for the
Lordship, can we
petitioner.
grant 1 week time for instruction.
MS N. Bordole, learned counsel appearing for the alleged contempt by placing the order dated 07/01/2025 submits that the order of this court dated 22/05/2024 passed in WPC number 2650 of 2024 has duly been complied with. List of the district commissioner, district commissioner, as the district commissioner Nagaon has directed the additional district commissioner in charge Nazrat branch Nagaon to take necessary arrangement to disburse the sanctioned amount of rupees 2 lakhs to the next kin of the deceased persons, namely the petitioner.
Yes.
Namely petitioner. Mr. In view of having considered about the order of this court has been duly been complied with. Accordingly, the contempt petition stands closed. The copy of the order so and so, dated so and so, placed by the
Lordship, one.
learned MS N. Hazrika N. Bordole Learned Council is kept on record and marked as document X.
What observation may be given within a period maybe it is, otherwise they will be taken again.
Go and collect
Lordship.
if you have not collect.
So obliged.
65.
May I please proceed?
Yes, sir.
The matter may come up for admission, my lord, in the next week.
Why?
No, because
Heard Mr. So and so
That is
Learned
right.
Council for the as prayed for by the as agreed to by and as agreed to by Learned Council for the parties, list this matter for admission hearing after 3 weeks.
my lord, he is in.
Can it be 19th of
Hmm.
19th of March? Can it be 19th period?
After 2 weeks.
Fix no for that.
Well, there are the interim orders here for fixing of
Interim
date.
order passed. Interim order is there.
Yes.
Therefore, my I'm paying for fixing of date. Mira.
Interim,
of date is
interim
paying
order
for-
passed earlier shall continue.
In the IA it has been passed.
He's
So
on-
what is the matter? What is the
No,
dispute?
he's just challenging the corporate, the deputy registrar and pass an order, my lord. He's challenging the same order before this court, but that interim order is under challenge. is not that-
2 weeks.
Yes, my lord. So, my lord, that may be fixed, my lord. 19th or 21, my lord. Kindly, my lord.
2 weeks, 2 weeks.
Then we'll
We'll
have to
take it
mention
after
again,
2
my
weeks, huh?
Then we have to mention it again, but therefore not listed normally. my
You
lord.
have mentioned it.
No, no, my lord.
No.
It's fixed matter.
Okay. After 2 weeks. Give the date.
Yes.
66. Lordship, myself also same pair, also. Admission is admission column here also. Because the government has not filed the affidavit and also we have filed some I also regarding the stock of the original land potatoes. So this Lordship.
Original what?
Potatoes number, name from the potato, Sita copy. So government has struck off his name since he is not still in the position. So
What is potadar?
he is the original potato of the land.
Pattadar.
Co-pattadar.
Ancestral property, you know, okay?
As agreed to by learned counsel for the parties, list this matter after 2 weeks
Date may be fixed out of the, I have
for
mentioned
admission
that.
hearing.
If Lordship permit me date. Deep levels. 67. Wait, please, your lordship. Lordship, as per office note dated 1/2/2025, notice have been issued to the private respondent, lordship.
Okay. Office note dated 01/02/2025 reflects that the notice has been issued to the respondent number 10 on 01/02/2020. Oh no, on this. No, issued to the respondent number 10. List after 3 weeks.
For admission, Lordship.
68.
Obliged.
I'm appearing on behalf of restaurant number 128, Miller. T. Bodua. I'm going to be allowed to file a appeal.
Then you heard Mr. So-and-so, learned counsel, and Mr. So-and-so.
T. Bodua for 128.
128.
5, 6, 7, and 9.
But then you mention their name, record their name, and then you write that. Huh?
Lordship for admission. Lordship.
Admission.
Obliged, your Lordship.
68.
In this matter, we have received the instructions, my lord. We'll be filing an affidavit, my lord, 3 weeks time, 2 weeks time may be given.
Already 1 month time was given by.
No, my lord, last date we have not.
Heard Mr. So-and-so, learned counsel for you.
My lord, on
Mr. Fukan
Fukan, my lord.
and
My lord.
Fukan, learned state council.
My lord, standing council GAD.
Still is got GAD. Praise for and is granted further 3 weeks time.
3 weeks time.
File affidavit.
My lord, one more time, my
Give
lord, respondent number, service on the respondent number 6 has been completed, my lord, because she's been, so service is completed, so madam may come up as a admission item.
Keep living.
Service is complete, my lord, on the respondent number 6.
MS B. Goyal, learned counsel, and appears for entered appearance on behalf of respondent number 4. 6.
Madam will come up for admission.
Let him file first.
She's for number 3.
3. Record all that now.
69.
May it please, your Lordship.
Yes.
This for the substitution petition, Lordship. That some petitioner number 3, 27, 49, 56, 67, 68, 69, 73 are died, Lordship. And their legal hair may be substituted. So in the IA page number 46, we have make a table for the legal hair of the petitioners.
40, IA. Any objection, sir? Heard Mr.
As for respondent 1, 2, 3, 7, and 8.
For petitioner and Mr.
RK Chaudhary.
RKD Chaudhary. DSGOA,
Yes, Lordship.
Deputy DSGI, and Mr. A. Bhattacharya for
Number 4 and 5.
London State Council. This is an application seeking substitution of the name of the legal representative, substitution of the legal heirs in place of the. This is petitioner number
327, 49,
327, 49,
56,
56,
56, 67,
67,
68, 69,
68, 69,
and 73.
and 73. Where it is?
Page 46, Lordship.
Page 46.
Page 46. Having considered the submissions and considering that of the learned counsel for the petitioner, and considering that the petitioners number so and so have expired during dependency of this writ petition, as well as the substitution not being the prayer for substitution not being objected to by learned counsel for the respondents, I deem it appropriate to allow this application. Accordingly, page 46, the legal heirs, namely so and so, so and so. You give this little 46, be allowed to be substituted. This is the petitioner number 3, 27, 49, 56, 67, 68, 69, and 70. Mr. The according what is it? The IA states allowed in disposal. In writ petition, in view of the orders, petitioners too. file amended cost writing. List of and a notice thereafter registry to incorporate the names of the newly implemented petitioners. Petitioners to take steps.
Deeply obliged.
May please the lordship. Already I have taken step lordship.
Yes.
Matter may be come up for admission hearing lordship.
No, we'll wait for some time. And Mr. So-and-so Land Council for the office note dated 10/3/2025 reflects that neither ID card nor unserved notice has been received back in respect of service of notice upon respondent service of notice upon respondent. This after 3 weeks.
71.
Makibur Usman. Yes.
The applicant here in India, along with others, they approached this court by filing a writ petition with the grievance that there is a project for a development of a road from Romia to Nagarjuli.
What is this IA?
Yes, I'm coming to it. With the grievance of the petitioners in the writ petition is that the measurement which is supposed to be taken from the middle of the road, it has been taken from the edge of the road, and thereby the petitioner's land has been acquired in more. Now, during the pendency of the writ petition, the authorities have demolished the boundary wall of the applicant with regard to dark number 251.
So what do we want? That is
Today, what for the IA I'm pressing, I'm pressing the IA, since they have already demolished the boundary wall, now only I pray that further demolition may not be taken place, as because the writ petition is pending, with regard to the, and no compensation has also been provided to the petitioners,
What is your prayer?
in the IA, for
Please to consider this applicable issue notice on the so-called as to why any appropriate interlocutory order is staying the further construction work of roads, especially in the land of petition. No, how can we do it still like this? It's listed for the first time.
No, IA is listed for the first time,
Okay, we'll issue notice. We cannot just stop the road construction.
It is notice.
Road is for what?
My
Public purpose.
public purpose.
We'll issue notice.
No,
Heard Mr.
I-
So-and-so,
I-
council for the petition.
IA,
Issue notice to the respondents.
Respondents are already here, dear government.
So we just cannot stop the road construction, sir.
The demolition of the petitioner's land, my lord.
Your prayer is to stop the road construction.
No, my lord, the boundary wall.
Order staying the further construction work of the road.
No, I'm praying that, my lord,
The land has been acquired.
land has been by way of a notice, my lord, but no compensation have been given till now.
He will
there's
get the
a-
compensation. If there is a delay, he is entitled for 9% of the interest rate. So accordingly, the question of any interim order
there is-
doesn't arise at this stage, Lord.
there
That's
is-
because it's a construction of a road, Lordship.
Yes. Now, my lord,
Heard Mr. So-and-so, land council for the petitioner.
my lord,
This is an application for seeking, praying for stay of the further construction of road in respect of
Dock number 251.
dark number 252, which is claims to be belongs to the applicant.
Applicant.
List of issue notice returnable by 4 weeks. We'll consider. We cannot stop the road
No.
construction.
Road construction will go
Next.
on, my lord.
Thank you.
Here, one line, my lord. That
No, we're not
there-
inclined.
there-
We're not inclined. We're not going to stop the
No.
construction of the road.
My lord, you give me 1 minute, my lord. There are some trees. Those may not be cut off, my lord.
That is
That is
not
without
that is
compensation.
not your prayer.
Without compensation, Lordship, we will get Lord.
You'll get everything.
My lord,
You want
yes.
the compensation
then-
and you don't want the road to be constructed.
Then, my lord, let the requisition be listed, my lord, for admission, my lord, in,
Next. I pass the order. We'll consider on next day.
72. I'm obliged.
What is this?
This is the IF4 typographical error. ma'am.
Huh?
Correction. This is the IF4 correction of the typographical error. It page number 8, my lord. Here, the Mr. Akastiv has already been implemented as it should be respondent number 3, my lord, instead of
Huh?
Mr. Akastiv here, page number 8. I filed one IS. By this IA, Mr. Akastiv was implemented as respondent number 2 instead of 3. It should be respondent number 3.
Respond number 4.
Respondent number 3, it should be respondent number 3. Yeah,
3.
3, yes, madam. Yeah, in-
Akashdeep Bias is respond number 2.
Yes,
Huh?
here it is inadvertently recorded as respondent number 2, but it should be respondent number 3.
Heard Mr. So and so, then will consider for the petitioner. This application is filed for correction of the typographical error in the order dated 13/03/2024,
13/08/2020.
passed in 13/08/2024, passed in contempt C number 700 of 2022. List of having your in the petition, it is correct. It is respond number 3
It was
in your petition.
in contempt petition, madam. It should be respondent number 3, madam.
Is it, have you written respond number 3 in contempt petition?
If, my lord, no, I have not filed the amended question paper yet, my lord. Notice may be issued at thereafter.
Huh?
Notice may be issued, my lord.
Notice may be issued in the IA.
IA has been disposed of, my lord.
Huh?
In contempt, IA has been disposed of.
So, which
In
IA?
contempt, my lord, this is the contempt, my lord. Page number 8, this is the contempt. Here it is recorded as
IA has been allowed.
allowed, yes, my lord.
Where it is?
Already disposed of by the IA.
Where it is? IA has not been
IA
this.
Earlier, IA has been disposed of. 2596/2023.
What is this 640? Where is 640? IA 640.
640, yes, madam.
This is for what?
This is for correction of typographical error, madam.
So that's what I'm saying. Whether this your in the contempt petition you have mentioned it respond number 3.
No, my lord. Here in contempt petition, 2 contemner is there, Anurag Goel and Binod Deka.
So?
I would like to implement this Akasdeep, my lord, in the contempt petition
You file an application.
for implementing. Implementing has been done, my lord.
Huh?
Page number 8, my lord. This is the IA, my lord. In view of the, may I read, my lord? In view of the order dated 13/8/24, passed in IA 2596/2023, Sri Akasdeep, IS Principal Secretary, PTC Kokrasa is implemented as respondent number 2. But it
Okay.
should be respondent number 3.
So this is for correction respond number 3.
3 years.
He has been implemented as respond number 3.
3 years, my lord. Inadvertently, it is recorded only 2, my lord.
For correction of the no, what is that? List of in the order dated 13/08/2024, the one Sri Akasdeep IS Principal Secretary BTC Cockrezer has been implemented by showing as implemented as respondent by showing as respondent number 2 inadvertently. Mr. Have been considered about this IA is in the applicant is allowed list up accordingly. The order dated 13/08/2024. In the last, in place of respondent number 2, same may be read as respondent number 3. List of accordingly, IA stands allowed. That's all.
Yes. Obliged.
23.
May I please, Your Honor?
Yes.
Your Honor, services completed upon the respondent.
Neither ID card nor answers have been received back in respect. Yes, you are submitting contrary to the record. Heard Mr. So-and-so learned counsel for the office note dated 10/3/2025 reflects that neither ID card nor answer notices have been received back in respect of respondent number 2, 4, 5, and 6. List accordingly list in view of the list matter after 4 weeks.
74.
May I please, Your Lordship?
Yes.
Your Lordship, we have filed this IA for amendment of the writ petition, Your Lordship.
Before proceeding further, my lord, we want to place one thing. The petitioner is a practicing advocate of Supreme Court of India, my lord.
No, Your Lordship, he is not a practicing advocate.
This
He
is-
has a degree of LLB, but he is pursuing for PhD, Your
I
Lordship.
extract his name from the
He had done a course in LLB,
by
Your
of
Lordship,
Supreme Court, my lord.
but he is not practicing advocate.
The address is.
He's preparing for his PhD, Your Lordship.
B13 Pandara Road, New Delhi.
Yes, my lord. The office address C7 first floor, Green Park, Main, New Delhi, pin code so and so. But this address is found, my lord, in page 321.
What is seeking?
he-
What is
he is
your
seeking to get-
what is your prayer in the writ petition?
So, Your Lordship, my prayer is that in this IA,
Not
that we
IA,
want
in the main.
to set aside the allotment that is in favor of the private respondent, Your Lordship.
Hmm.
The matter pertains to the dealership of an allotment to HPCL petrol pump, Your Lordship. So, which is in favor of the private respondent.
But if it is allowed, my lord, the character of the petition will be changed, my lord.
Will
Because
issue notice at this stage. Heard MS so-and-so learned counsel for the petitioner. Whatever you want to file an objection, you file. Hmm. This is an application seeking amendment of the connected writ petition being WPC 3777 of 2021. Issue notice to the respondent. Mr.
That's what I would-
S. Borwai, Bortakor, Land Council,
That's number 226, my lord.
you are one.
427.
And who is what for one?
This is my lord.
Union.
Mr. SS Roy was appearing last week.
Huh?
Sir, SS Roy, my lord.
Mr. So-and-so and Mr. S. Bortakor, Land Council for the respondent 2 to 8.
I am for 2
Huh.
6, my lord.
You are
He is for 7, my lord.
47, madam.
2 to 7
Yeah, put a charge.
appears. Enter the appearance. For enter the appearance and accept notice on behalf of respondent number 2 to 7. No formal notice need be served. However, extra copies be furnished to the land council for the respondent 2 to 7. How many respondents? One.
Seven, Your Lordship.
Okay.
At the same
The
time,
petitioners to furnish copy of the IA to the learned CGC. Respond number 1.
At the same
List
time-
after 3 weeks.
At the same time, they have to clarify whether he is a petitioner is a practicing advocate or not, my lord. Because rule 47 by Argyle
You file an objection and then we'll
Yes.
take it back.
Deeply
Then
obliged.
we'll see.
75. Well, step second, madam, is from the office note 5(3).
Hmm.
It is shown that the private respondent number
Sir,
7.
Mr. P. Mahanta, learned counsel for the petitioner. Office note dated 10/3/2025. It reflects that neither Edgar nor answered notice.
10(3), my lord.
Huh?
10(3) is, my lord, the order, and neither Edgar nor, my lord, this is.
Yes. So,
This is 10(3), my lord.
10/3.
Yes, ma'am.
2025 reflects, huh? That neither Edgar nor answered notice has been received in respect of respondent number 5. Respondent number 7. In view of the
what-
matter after 3 weeks.
My lord, one prayer, my lord, this is a private respondent, but the main respondent are 1 to 6, they have received the notice and they have been represented by the advocate concerned. So, my lord, my prayer is, my lord, because the matter is relating to the receiving the compensation, it is already been decided, my land has been taken. So they should come with the all instruction in next that, so that may be disposed of, my lord.
The respondents
1 to 6.
1 to 6 may
It is-
file their
His
response.
name is there, my lord, their name also there,
May file their response.
date is given, my lord,
Okay.
date is given, my lord.
Compensation? What's
My lord,
why
because
not-
my
why
matter is
not?
been long pending.
Huh?
It is already been required in long back, 2000.
This is 2025.
No, this is matter I came, but the process was initiated.
We'll
2 years
go by,
back.
we'll go by the
But this is a direct purchase.
seniority of the writ
This is
petition.
direct purchase.
Not
It is
the claim,
that
not
sale
the
did-
claim.
Sale was completed, my lord. This is the thing, my lord.
We'll see.
Possibly.